Yes, Mr. Sharma.
My lords, item number 9 of the daily list, as well as item number 21 and 22 of the supplementary list, my lords, that those items may be taken up at 2 because the senior government advocate, Mr. D. Nath, he will be on legs in court number 1 in the first half, my lord.
Okay.
Obliged, sir.
May I please your lordship, daily list item number 4. I beg to mention that my senior is in bereavement, so kindly pass over the matter.
What happened to Mr. Dhar? What happened to Mr. Dhar?
Sir, lordship, he is in bereavement.
What happened? Who expired?
Elder brother. Highly obliged.
May I please your lordship? Lordship, I beg to mention item number 6, lordship. Can it be taken up next week, lordship?
We are not passing any order at this stage, 2018 matter. Let the matter reach because we are having other matters. That matter may not reach also at this stage. Let us see.
Lordship.
Mr. Sharma.
Yes, Lordship. Probably, Lordship, I have the instructions for the time being, Lordship.
No, what has happened? The record was called for on many occasions. Why there is no reply? In fact, in 2018, it was called for. 2023, it was called for. By last order, it was called for. Can you tell us the reason why? Otherwise, we have to think in another way.
Yes, Lordship.
Please, Lordship. Lordship, senior will come, but due to traffic jam, but he will not come. File is not available in my head. After some time,
Get the information.
Yes, Lordship. At
We'll
2
take it up
Lordship.
at 2 o'clock.
Yes, Lordship.
This was at Saridwar, Balipara. This is in Sonitpur district only.
Sir.
Balipara is in Sonitpur district. Mr. Sharma.
Answer was called from answer not received, my lord.
Let us see. Get the information from the concerned tribunal, Mr. Sharma.
Yes, yes,
What
Lordship.
happened? Otherwise,
Yes.
we'll pass an adverse order.
Yes, Lordship.
At 2, my lord.
At 2, at 2.
Please.
Lordship, iron is not available, Lordship. For the time being, Lordship. For the time being, past body method, Lordship. He will come, Lordship.
By what time?
Lordship,
We'll hear Mr. Day.
Lordship.
Yes, Mr. Day, come to page number 68 stated. Let us see the opinion.
Well. May I read now?
Yes, please.
The case against the above named OP in brief is that OP has been suspected to be a doubtful citizen foreigner. And as per ERO and LVO's report of 22 South Shalmara LAC, the SPB Dobri competent authority has forwarded this reference to this tribunal to decide the nationality of the said OP under the Foreigners Act 1946 amended 1964. The reference so received is registered accordingly, and on the receipt of the notice, OP appeared and filed a written statement along with copies of documents denying the truth of the allegations and inter alia claimed that he is not a foreigner as alleged. As such, as much as his OP's parents are genuine Indian citizens having the right of voting in the year 1966, 1970 at village 180 Borkolia Nashkora under the same 32 South Salmara LSC. In support of the claim of the OP submitted evidence in chief on affidavit along with copies of the following documents exhibits of himself as OP DW1, his cousin brother as DW2, and the summoning witnesses office assistance of settlement office as DW3 under Order 18 Rule 4 of CPC. State has no representative to cross-examine the witnesses. So, for clarification, tribunal refers to the witnesses. The post of SGP was lying back in so and so. The following documents are submitted by OP in support of his claim by marking as exhibits. Attested certified copy of NRC 1951, certified copy of final Khotian of village Sarakura Part 1, certified extract copy of Electoral Roll 1966 Exhibit 3, certified extract copy of Electoral Roll 1970 Exhibit 4, certified extract copy of Electoral Roll 1977 Exhibit 5, certified extract copy of Electoral Roll 1985 Exhibit 6, certified copy extract copy of Electoral Roll 2010 Exhibit 6(1), photocopy of voter ID Exhibit 7 and 10, certified extract copy of Electoral Roll 1966 Exhibit Y submitted by DW2. Engaged advocate for the OP argued before the tribunal in support of OP's claim, and a state representative SAP argued for the state. Point for determination whether opposite party is a doubtful citizen, foreigner or not. Decision and reasons thereof. As per provisions of Section 9 of the Foreigners Act 1946, the onus of proving that the OP is a citizen of India and not a foreigner lies upon the OP. Now, let us find out as to how the respondent OCD OP could be able to discharge his burden to prove that he is not a foreigner. I have carefully perused the case record along with the evidence of OP, DW1, DW2, cousin brother of OP, and the summoning witness, DW3, Office Assistance of Settlement Office, along with the exhibited documents. The OP, DW1, Amjad Ali, in his evidence inter alia, deposed that he, OP number DW1, is an Indian citizen by birth, being born at village Sarakula, now PS Fakirganj, district Dhubri, and that his OP's father's name is Rohim Baksha, and mother's name is Chandrabhan Bibi, and stepmother's name is Guledan Nessa. OP as DW1 further deposed that his parents are also genuine voters in the year 1966 and 1970 at village Borokolia, Nashkara, under the 32 South Salmara LAC. The OP as a DW1 further deposed that his father's name was recorded in the final Khotian as Khotiandar with his uncle's name. Further, DW1 OP stated that his name is recorded at village Borokolia, Nashkara in the voter list of 1985 with his mother and wife under 22 South Salmara LAC. DW2 Akhtar Hussain, son of late Jabbar Ali Sheikh, cousin brother of OP, in his evidence inter alia deposed that he DW2 is a genuine voter since the year of 1970 at village Salakura under 32 South Salmara LAC, having the voter ID card and that of OP, OP is his cousin brother. DW2 deposed that his DW's father's name is Abdul Jabbar Sheikh, alias Jabbar Ali Sheikh, who is the elder brother of Rohim Baksha, father of OP. DW2 further deposed that due to erosion of river, his parents, including himself, shifted to village Bogulamari Part 1, PS Gauripur, DW3 summoned witness Kamalakanto Rai, office assistant of settlement office Dhubri, in his evidence inter alia deposed that in the final Khotian register book recorded the name of Rohim Baksha, son of Kanduk Sarkar, and others as Khotiandar in the year 1962. Thus, in view of the above evidence of the OP, DW1, DW2, OP's cousin brother, and the summoning witness, office assistant of a settlement office as the DW3, coupled with exhibits, the OP wants to prove his citizenship through the paternal identity and the relationship of Amjad Ali as the OP of this case. Now the reasons and decision. Exhibit 2 is the certified copy of final Khotian of village Chalakura Part 1, wherein recorded the name of Rohim Baksha, son of Khudu Sarkar as Khotiandar. Number 2, with others. In this regard, OP summoned to the officials of settlement office Dhubri and accordingly appeared Kamalakanto Rai, one office assistant of settlement office Dhubri as DW3, and deposed that the submitted certified copy of the final Khotian was issued from the office of the settlement officer Dhubri, and in the final Khotian register, the name of Rohim Baksha is recorded as Khotiandar, which was prepared on 1962. It proves the existence of Rohim Baksha, son of Khudu Sheikh, was the landholder person at that time. Exhibit 3 is the electronic certified extract translated copy of electoral roll of 1966 of village Borokolia, Nashkara under 32 South Salmara LAC, wherein the OP claims that his father's name Rohim Baksha, son of Khudu Sarkar, and mother's name Chandraban Nessa Bibi, wife of Rohim Baks, appeared. In the submitted electoral roll, Exhibit 3, the column of age is found blank. So the age of the person was not ascertained as per submitted voter list. The OP ought to have been explained the age of the person as appeared in the submitted voter list. As per voter list, without age, identification and relation of the person cannot possible. Exhibit 4 is the certified extract copy of electoral roll 1970 of village 180 Borokolia, Nashkara under 32 South Salmara LAC, wherein the OP claims that his father's name Rohim Baks Sheikh, son of Khudu Khuju Sorkar, aged about 49 years, mother's name Chandraban Bibi, wife of Rahim Box, aged about 29 years, along with his brother Ansar Ali Sheikh, son of Rahim Box, aged about 29 years, appeared. As per submitted voter list, the age of Chandraban Bibi, that is mother and her son Ansar Ali Sheikh is Sheikh. The OP has not properly explained about the age discrepancy found in the electoral roll. So a serious doubt is created regarding genuineness and identity of the person whom OP projected as his mother and brother. Exhibit 5 is the certified extract copy of electoral roll of 1977 of village 180 Brocolia, Nashkara under 22 South Salmara LAC, wherein the OP claims that his mother's name Chandraban Beva, wife of Rahim Baksh Sheikh, aged about 35 years, and his own name Amjad Ali, son of Rahim Baksh, aged about 25 years appeared. The age difference between OP and his mother is only found 10 years as per submitted voter list, which is impossible as because OP has disclosed during cross-examination that he has 3 elder brothers of his own. The OP has also failed to explain the discrepancy, so doubt is created about the genuineness of the person. Exhibit 6 is the certified extract copy of electoral roll of 1985 of village 180 Borokolia Nashkara under 22 South Salmara LAC, wherein the OP claims that his mother's name Chandraban Beva, wife of Rahim Baksh, and his own name Amjad Ali, son of Rahim Baksh, along with his wife Sharbanu Bibi, wife of Amjad appeared. Exhibit 6.1 is the certified extract copy of electoral roll of 2010 of village 126 Sialmari under 22 South Salmara LAC, wherein the OP claims that his name Amjad Ali Sheikh, son of Rahim Baksh Sheikh, along with his wife Sharbanu Bibi, wife of Amjad Ali Sheikh, and his son Mohar Ali Sheikh, son of Amjad Ali Sheikh, appeared. The name of OP is appeared at village Sialmari in evidence in chief or in the written statements of OP has not explained about his shifting from village Borkolia Nashkara to village Sialmari. The OP Amjad Ali, son of Rahim Baksh of village Sialmari, and Amjad Ali, son of Rahim Baksh of village Brocolia Nashkara, definitely not same person. The OP Amjad Ali of village Bokolia Nashkara projected himself as Amjad Ali of village Sialmari. As per submission of OP, the tribunal allowed to OP for authentication of submitted voter list from the concerned election office, and accordingly, an authentication report from election office South Salmara, Mankasar, Hatisingimari has been received on 3/9/2019, stating that the certified copy of the voter list of 1966, 1970, 1977, 1985, and 2010 as submitted by the OP are genuine. The report also disclosed that due to their oversight in voter list of 1966 and 1970, the name of Khudu Sorkar and serial number are wrongly written in the certified copy. After perusing the report and enclosed printed copy of voter list of 1966 and 1970, the serial number with age number with serial number with page number are found different. In the report enclosed printed copy of voter list 1966, the first page end at serial number 86 and in back page without page number, serial number begins from 91. Same as in the voter list of 1970, first page end at serial number 90 and in the back page, next page, without marking page number begins from serial number 191. So, so after observing the anomalies in the voter list and the report, the tribunal is not satisfied with the authentication report of election officer South Salmara, Hatisingimari, and accordingly, the report is not accepted. The OP also did not call for the election officer to probe the voter list from the original electoral rolls. From the above discussions of the exhibits and as well as the evidence on record, the OP has failed to establish his linkage with his either parents, whom he claimed to be his father and mother as he projected. In the absence of the other corroborative evidence, documents, the other post of 1971 documents cannot be accepted. Hence, these are not discussed. And the post of 1971 documents cannot establish the parents, establishing the parents' existence in the Indian oil prior to 1971. So discussion of other evidence and the documents exhibit is not necessary since redundant. Moreover, the law is well settled that just because name of a person is enlisted in the voter list, it would not mean that he is a citizen of India. Enlistments of name in the voter list or long stay in the country are no proof of citizenship. Net result of the above discussion is that OP is unable to establish his linkage with an Indian parents relatable to a period from prior to 25/3/1971, which is the cutoff date for identification of foreigners in the state of Assam as per Section 6A of the Citizenship Act 1955 as amended. The narrative presented by the respondent OP suffers from multiple contradictions and omission, rendering the same is highly suspected and wholly improbable. Thus, the OP has failed to discharge his burden under Section 9 of the Foreigners Act 1946 to prove that he is not a foreigner but a citizen of India. Accordingly, considering all aspects, the OP is declared as a foreigner under Section 2A of the Foreigners Act 1946, and the other members of his family also falls under the category of Section 2A of the Foreigners Act 1946. As such, I declared the OP Amjad Ali as a foreigner of post-1971 stream, and accordingly, it is ordered that the OP is to be taken into custody by the SP Dhubri immediately and be kept in appropriate place till OP is deported, forced back to his original territory. Simultaneously, his OP's name shall be deleted from the NRC voter list, if any. The government shall cancel the name of other family members of the OP from any government beneficial scheme, family ration card, voter ID card, driving license, etc., and initiate fresh references against the other family members of the opposite party. The case is stand disposed of on contest in terms of the above discussions. Accordingly, reference is answered in the affirmative and against the OP.
Where is the illegality? Now just tell us one by one.
My lord. My lord, here, my lord, regarding 2 points regarding age. Age anomalies, my lord, it is common in the voter list, my lord. So it is not minor, my lord, age listing of age in the voter list, it's a minor discrepancy, my lord. It should be, my lord, liberally look into, my lord. And there is also some decisions in this regard that the age of the voter persons in the listed in the voter list should be liberally interpreted, my lord. And number 2, my lord, the voter list, regarding the voter list, the concerned official has submitted a report that the voter list of 1966, 70, 77, 85, 2010 are all genuine. But the learned member, my lord, has interpreted it with respect to the photostat copy annexed with the report, my lord. My lord, where certified copy is available and it is admitted fact by the reporter that some mistake has been committed by the office. So for the mistake of the office, my lord, whether petitioner has to be suffered, my lord, that aspect of the matter is to be looked into, my lord, because this certificate copy is issued by the concerned authority, my lord. So if a tribunal has not satisfied with that report, may call for fresh report also, my lord, for verification. That was not done. And though the notices was issued to the, my lord, kindly see the records also shows that notice was issued to the electoral officials, my lord, to come and probe those documents, my lord. But the officials, in spite of received the notice, they have not turned up to come to the tribunal, my lord. So, my lord, that aspect is there, my lord. It may be, it is the case, my lord, if these things are considered, it is the case, my lord, to remand back the matter to the foreigners tribunal to decide afresh. And moreover, my lord, regarding evidence of DW2, my lord, there is no discussions in the evidence in the tribunal decision of the tribunal, my lord.
It's very much there at the top. You have just read.
Top, my lord, it is submission has been recorded. But my lord, when documents and evidence is given, it is to be discussed by the tribunal. And there is a decision, my lord. Without discussions, it cannot be said that they have considered, the tribunal has considered the evidence, my lord. There is a decision I will submit, my lord, that some decisions are there. So this also is another cause to remand back the matter to the tribunal to give a fresh decision after considering the evidence of DW2, my lord. So, my lord, these are the main grounds, my lord, I have challenged this decision before this honorable court. Number 1, the age discrepancy, my lord, I beg to cite one decision, that is 2021 GLT, page 330, Motiur Rahman versus Union of India.
2000.
2021 GLT.
Page number.
Page number, my lord, 330. Paragraph 11, my lord. I beg to cite paragraph 11. My lord, this decision I have obtained from Supreme today. Paragraph 11, my lord. We also find from the record that the learned tribunal has declared the petitioner as a foreigner based on some minor discrepancies in recording the age and also for non-mentioning of the date of second marriage of the father of the petitioner. However, such discrepancies in our opinion are minor in nature and hence, even if found correct, would not have any material bearing in the outcome of the writ petition. Moreover, the decision of the Honorable Supreme Court rendered in the case of Shirazul Haq versus State of Assam, the others in connection with the criminal appeal number 267/2019 arising out of SLP number so and so, it has been held that minor discrepancies in recording names, age and address of the family members of the proceeding cannot be a ground to doubt his case.
Read Sirajul Haq.
My lord. Sirajul Haq, my lord.
Judgment of the apex court.
My lord. Okay, yeah. My lord, Sirajul Haq in paragraph 4,
Read para 3 and 4 of the Sirajul Haq.
my lord, 3 and 4. We have heard learned counsel for both sides extensively and have gone through the documents produced by the appellants ourselves. On a perusal of the same, we find that a number of documents have been relied upon by the appellants, starting with the voter list of his grandfather, Kematullah, in village Shuktubarjani. There is no doubt that the great grandfather's name Amtullah appears as Amtullah throughout the document. Equally, there is no doubt about the father's name, which appears in Hakim Ali throughout. The only discrepancy found is that the same of the document in some of the documents, Kefatullah later becomes Kematullah. However, what is important to note is that his father's name Amtullah continues as Amtullah, and the other family members associated continued as such. Also produced are NRC, the registration details of the year 1971 of the grandfather, who is noted to be Kefatullah in this document. Other voter lists are then produced, where the letter F becomes letter M, with other family members remaining the same. In fact, appellant has himself produced a document of 1981 from the Income Tax Department giving this permanent account number. Apart from these documents, certain other letter documents have also been produced including photo identity cards issued by the Election Commission of India and identity cards issued to his brother, including voter list in which the appellant's names appears. Having gone through these documents, we are of the view that it is not possible to state that Kematullah is not the same despite being named Kefatullah in some of the documents. This being so, grandfather's identity, father's identity, etc., has been established successfully by appellant. Further, the mere fact that the father may later have gone to another village is no reason to doubt this document. We therefore set aside the judgment of the High Court as well as the
Honorable Apex Court.
My lord, there is the names
Where-
difficult
where is it in
Kematullah,
Apex Court? Can you
Kefatullah.
show us that the discrepancies in age, discrepancy in other things,
My lord,
hardly it matters. Where is in the Apex Court judgment it has been mentioned? Which particular paragraph?
My lord, here in Sirajul Haq, mainly, my
Has
lord,
it been observed by the apex court?
no, my lord, age matter is not dealt with, but
why?
the name,
Why the apex court did not deal it with the age matter, you know? Because the Representations of the People Act is very clear. If any voter finds any fault with his address, name, age, he is required to correct it. And that is why initially a final voter, before finalizing the final voter list, publication of the final voter list, there is a other voter list for checking of the people. It is not new in the
My lord.
Representative People Act.
My
It's an
lord.
old act. And that is why the Honorable Apex Court did not state in
age
this particular
regarding age.
judgment, but what they found that the name of the family members remained intact,
My lord,
excepting a particular letter of Kafatullah and Amatullah.
Kamatullah.
So when they found that in this particular village, these 4 or 5 persons are there,
My lord,
Kafatullah was there, they have shifted to another village. All these were only one letter, and that was missing,
my lord.
and it was substituted by another letter. So that is the reason that shifting is also doesn't matter there in that background. Kindly show us from this particular judgment when
My lord,
lordships in the Honorable Apex.
my lord,
Court
in our case also, my lord, from the very beginning of 1951 NRC,
Hmm.
the person
NRC is
66
not a
voter list, 70 voter
As
list,
you know, NRC is not a-
85 voter list also, my lord, contain the names.
Very good. Now
My lord.
show us the name of your mother.
My lord, my mother's name with my father's name is recorded, my lord, in the
As
voter
what?
list of 1966.
As what? In the voter list of 1966.
My lord,
As what?
Rohib Ali box, Chandraban, Rohim box Sheikh, Chandraban Nesa Bibi,
Chandrabhan Nesam Bibi.
Bibi.
There is no age. That is the reason.
Age, there is no age.
There is no age, and that is the reason the tribunal has rejected. Rightly,
My
there
lord.
has to be an age.
And the-
because
and
we are
the-
not able to identify.
And my lord, it is also record was called for, a report was called for. A report says this voter list is genuine.
It was, that is why the tribunal found it's a photostat copy not been proved.
My lord,
There
this
is
is a
no
certified
age.
copy, my
Come
lord.
to the next, which is a certified copy. Certified copy without age,
Yes, certified copy without, but the record is also such, my lord, as per report.
that is the.
My lord,
reason.
I beg to submit another, that is Motalib, Abdul Motalib.
We'll come to that. You come,
My
show
lord.
us the next voter list.
Next voter list, my lord, 70 Rohim Box Sheikh, Chandraban Bibi, Ansar Ali Sheikh,
Initially, it was Chandrabhan Nesa Bibi, now Chandrabhan Bibi.
my lord.
Earlier, it was
Chandraban Nesa Bibi.
Hmm.
Here is Chandraban Bibi.
Hmm.
My lord, in my written statement,
Okay.
paragraph 12, I have stated that Chandraban Bibi, Chandraban Nesa Bibi, these are all same person, my lord. In the WS paragraph 12, I have stated.
Then
May I read, my lord, paragraph 12 of the written WS,
we have seen that.
my lord.
Next,
Then, my lord,
after 70,
after 77, Chandraban Bewa. Then after the death of her husband, it is written as Bewa.
don't pronounce it as Chandrabhan. Pronounce it as Chandraban.
Chandraban. My lord.
Hmm.
Chandraban. Sorry, my lord. Chandraban. Amjad Ali is the son, my lord. Here the petitioner.
Yesterday, we asked you why his name for the first time figured in the voter list of 1977, while he was 25 years. Why not prior to that?
My lord, continuously, Chandraban, Bewa is a continuously,
Why
then
Amjad
85,
Ali-
2010 also.
Mr. Day,
It is continuing, my lord. Some,
why Amjad Ali's name figured in the voter list for the first time while he was 25 years in 1977,
my lord,
though he was eligible to vote at the age of 21 years.
my lord, maybe some initiative was not taken, my lord. Otherwise, my lord,
Hmm.
Rohim Box, son of Rohim Box,
Hmm.
Chandraban Bewa, wife of Rohim Box Sheikh. These things are tally, my lord.
Why after 1977, it is only in 1985?
1985,
Why? Why not?
77. Chandrabhan, Bewa, Rohim Box.
Why
Amjad
only
Ali.
85? What happened in between? During this
No,
period of
that-
8 years? We are asking you to clarify.
Both Kaliya Nashkara. Exact reason, my lord, I cannot say, and voter list, my lord, perhaps some voter list may not produce also. Exactly, I cannot say, my lord. And then shifting the 2010 voter list also there, Amjad Ali Sheikh. Shohar Banu is the wife of Amjad Ali. Mohar Ali his son. Amjad Ali Sheikh, Shohar Rohim Box Sheikh. Voter identity card also there, my lord. These things are there, my lord. Continuously, my lord. If we see that the continuously recording his names. The family members. And in the WS, he clearly stated the family member's name. And in my lord 2020 4GLT, page 611, it deals with that, my lord. Once the petitioner places the evidence, documents, it should be considered by the
4GLT.
2020 4GLT, page 611. Farida Khatun versus Union of India. Paragraph 10, my lord. Hmm? Paragraph 10, my lord. The aforesaid interpretation itself gives the petitioner proceeding a wider choice of evidence in order to prove her citizenship by any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature, or extent of any right, liability, or disability asserted or denied in the proceedings necessarily followed. Accordingly, the petitioner has the right to rely various facts which must be relevant, keeping in view of the facts in issue. Once the petitioner places the evidence, the tribunal is bound to consider each and every such evidence in order to decide its relevancy and admissibility of the evidence. In the search for relevancy and the proof of contents thereof in the case of documentary evidence is not the same. Relevancy relates to the facts and issue before the tribunal, which are undoubtedly the facts pleaded by the proceeding and the degree of veracity that can be attached to it. So the said exercise requires discussion and reasoning. And if there is no such discussion, then it would be amount to non-consideration of a particular fact pleaded resulting violation of principles of natural justice affecting the proceeding. Once a document is held to be relevant, then comes to the issue of probing the document and the contents thereof, while searching for the relevancy of the tribunal is bound to consider the oral evidence along with the documentary evidence, documentary one, or as all facts cannot be proved only by documentary evidence.
Where is the tribunal have decided that's a relevant document
My lord,
to consider the evidence of DW2?
my lord, DW2. DW2 in the reasons, there is no discussion, my lord. In the judgment, there in the order, opinion, where the reason and decisions discussed, no discussion at all, my lord. DW2, witness of evidence of DW2, my lord. There is no discussion. So it must be discussed, my lord. And given reasons. Nothing mentioned about in the decisions, my lord. And the paragraph 12, my lord, in view of the discussions above, we are of the considered opinion that there is an error apparent on the face of the impugned opinion, as the learned member failed to discuss the evidence on the record. And as such, we are inclined to allow this writ petition by setting aside the common impugned opinion dated so and so. And also accordingly, do and remand the same with the direction to consider the evidence on the record and to pass opinion as per law. It was remanded back, my lord, on this ground, my lord. And in another case, my lord, that is 2019 1 GLT, 2019 1 GLT, page 393.
Yes.
My lord, this is the Rajabali versus Union of India. My lord, in this case also, Rajabali. Paragraph 12, my lord.
Yes. What is the proposition?
The proposition, my lord, that whatever may be the value of the outcome of they have to consider the documents. My lord, paragraph 12. Whatever may be the nature and value of the evidence adduced by the parties, the same requires to be considered while arriving at a decision by the learned tribunal, which has not been done in the instant case by the learned tribunal. More particularly, we find Exhibit Z has not been at all discussed by the learned tribunal and in its order dated so and so, notwithstanding the relevancy and admissibility thereof. My lord, evidence is there, it's supposed to be discussed, my lord, and considered.
Okay.
My lord. And then the Abdul Muttalib, my lord, your lordship knows the Abdul Muttalib states that the petitioners are not participated in the listing of the voter age of the voter list. And it is the duty of the authority.
Read the Representation of the People Act and see what is there. See the rules. What is the correct proposition as per the Representation of the People Act? In which manner the address, name and the age should be incorporated? And then tell us. Save. Sirajul Haq case is one of the case where the Honorable Apex Court
My lord.
not deciding any such issues of the Representation People Act came to the conclusion only because they found the name of the other persons in the voter list remained intact. That is why court was fully aware. If, as per the Representation of People Act, the voter list is published as you have just said, nothing. If it has to be corrected, as per the same.
My lord, I have given in the WS as well as evidence I have stated the various names mentioned in the voter list. My lord, this is the same person that the
If you
statement
are
is given.
accepting
my lord.
those voter lists, then you have to accept in total. You have to also accept the age difference of 10 years. Think over.
My lord, the age
Where
factor,
is
my
that-
lord,
where is
age
that
factor,
law?
age factor, my lord.
Well, that's why I'm asking you. The court wants to inform you how the age to be corrected in a voter list.
My lord, in 85 voter list, all the ages are corrected, my
You
lord.
might have been corrected
85.
later.
In the 85 voter list, the ages of the mother and the
But if you
petitioner
have- if you
are
have-
rightly
if you have
recorded, my lord.
accepted 85,
85.
then it is,
Perhaps, my lord, subsequently it is corrected in the 85, 1985.
then it is Chandrabhan Bewa, not Chandrabhan Bewa, not Chandrabhan Bibi, and not Chandra Nesa Bibi.
My lord,
Everything will change.
for that, my lord, I have to submit a paragraph 12 of the written statement, my lord.
Have you ever stated that you have corrected in the year 1985 in your written statement?
My lord, I have given a statement only that, and the OP mother name recorded in the voter list of 1966 as Chandraban Nesa Bibi, and in the voter list of 1970, Chandraban Bibi, and the other voter list, Chandraban Bewa, are all the name are same and one identical person, that is OP's mother. That clarification is given.
What happened to Ansar Ali Sheikh? When did he expire?
Answer Ali, my lord, so far I have got information that he is the step half brother, but that means he is the first wife's son. First wife's son is the Ansar Ali, my lord. Not his own brother, biological.
When did he expire?
My lord, I have stated in my writ petition.
When did he expire?
My lord, he expired long back, my lord. In the WS it is stated, my lord. Stated. Deceased. Answer deceased. Ansar Ali Sheikh deceased. It is not mentioned when he died, my lord. Only deceased. Written as deceased. The half-blooded brother, my lord, of the petitioner, Ansar Ali.
Yes, Mr. Sharma, where is Mr. Pan?
Lordship, you come, Lordship. Otherwise, Lordship, regarding discrepancy in name and age, Lordship, it is not a minor discrepancy, Lordship.
Kotian also, my lord, Jobbar Sheikh, Rohim Box, Gofur Sheikh, Asiruddin Mastar. All are sons of Khudu Sardar.
On relates to. No, it is. Kolhapur, Kolhapur. Yeah. Adana to নির্ধারণ করা Adana কিমান দিয়া এতিয়া PW3 6000 সমান মই আজি তাকে Yeah. More specific. Take your seats, take your seats.
Well,
One details. That is- Here the has been forget. Yeah. Where, here. Interesting story. Even. Yeah. Portfolio now. Okay. Harmony. Okay. Kalapura, 031. My name. Zero something. Yeah, I know. My uncle. And our residents. Two. ঠিক আছে? অনেক আছে। কোনো কিছু আছে? কোনো কিছু করতে করতে এতিয়া বৰষুণ দি আছে। এটা proof. Mr. Day. With the affidavit in evidence of PWC, your protected cousin brother.
DW two, page 58.
Read slowly.
I, Akhtar Hussain alias Akhtar Hussain, son of late Jabbar Ali Sheikh, aged about 66 years, resident of village Bagulamari, Part 1, PS Gauripur District, Dhubri, Assam, do hereby solemnly affirm so and so. That I am the genuine citizen of India by birth, and I am born and brought up at village Talakura, and my forefather also born and brought up at the same village, that is village Salagura. My grandfather named Hudu Sheikh and grandmother named Hausi Bibi. Both are died since long. My father were four brothers, namely Abdul Jabbar Sheikh, my father, Rahim Bakso, Elias Baksha, Opi's father, Asiruddin Sheikh, Gofur Ali Sheikh. Opis are five brothers and two sisters, namely Ansar Ali Sheikh, deceased, Jamsher Sheikh, deceased, Shamsher Ali Sheikh, deceased, Amjad Ali Sheikh, OP, Boshiron Bibi, Toshiron Bibi, Munaf. That I am a genuine citizen of India by birth. I am casting my vote regularly with my parents. The Election Commission of India have issued electrophoto identity card by number so and so, village Bagulamari, Part 1. Exhibit X is the EPI card. that my name has been recorded in the voter list of 1970 with my parents at village Chalagura by number, serial number 178, house number 50, under 32 South Salmara, LSE. Exhibit Y is the voter list of 1970. That my father Abdul Jabbar Sheikh, alias Jabbar Ali Sheikh, elder brother of OP's father, was died, leaving his only 5 children. Akhtar Hussain, alias Akhtar Hussain, Akhtar Hussain, myself, Usub Ali, Yusuf Ali, Momtaz Ali, Jahanuddin, Rohim Ali, we are all are alive. That my father named Abdul Jabbar Sheikh and uncle named Rohim Baksha, alias Bakso, grandfather Khudu Sarkar, including other family members. Their name has been recorded in the NRC 1951 at village Chalagura, PS Dhubri district, Gwalpara, Assam, by the house number 250, house number 20, serial number 1 to 25, 1 to 15. Exhibit 1 is the copy of NRC 1951 submitted by OP. That my father Abdul Jabbar Sheikh and uncle Rohim Bakso, alias Bakso, and other 2 brothers, namely Abdul Jabbar Sheikh, A. Ghaffur Sheikh, Asiruddin Master, they are all son of Hudu Sarkar. Their names has been jointly recorded in the land document, that is final Khotian at village Chalagura part 1 by the Khotian number 12. Exhibit 2, the copy of said final Khotian submitted by OP. That thereafter my uncle Rohim Box and our residential house and landed property was eroded by the river Brahmaputra. Then my uncle residential home shifted from village Chalagura to village Vorkolia Naskara, PS South Salmara, and my parents' house has been shifted to village Bogolamari, part 1, PS Gauripur, district Dhubri, Assam. My parents' name jointly have been recorded in the voter list of 1966, 1970 at village Borkolia Naskara by the house number 68-4 and 64 serial number 159 to 160 and 229, 230, 231 under 32 South Salmara, LSE. Exhibit 3, 4 is the copy of voter list 1966, 1970 submitted by OP. That after death of my uncle, OP's name Amjad Ali have been first time recorded in the voter list of 1977 with his mother Sonraban Bewa. In the voter list of 1977 at village Borkolia Naskara with common house number 97, serial number 60 and 61. In the meantime, due to delimitation of assembly constituency 32 South Salmara LSE converted to 22 South Salmara LSE. Exhibit 5 is the copy of voter list of 1977 submitted by OP. That after a long period, the eroded area of Chalagura created a new chore, that is OP's birthplace. Then OP, including his all family members, shifted his residential house from Vorokolia Naskara to my birthplace, that is Chalagura, and started residing there by constructing a dwelling house without any information to the authority concerned, and recorded their name in the voter list of Chalagura GP. Hence, in the voter list of 1997, OP's name has been shown as D voter at village Borkolia Naskara under 22 South Salmara LSC. Exhibit A is the voter list of 1997 of Borokoli and Ashkara submitted by OP. That thereafter OP and his family members' name has been recorded in the voter list of 2006 and 2010 and the other voter list at village Chalagura. Annexer B and C is the printed copy of voter list of 2006 and 2010 submitted by OP. Annexer D is the printed copy of voter list of 2015. Annexer E is the printed copy of voter list 2017. Annexer 7 is the electro photo identity card. That OP's name Amjad Ali has been recorded in few papers and documents, and Amjad Ali Sheikh has been recorded in few documents. Both the name are same and one identical person, that is OP. And my uncle name has been recorded in few documents, Rahim Boxo, and in few documents, Rahim Boxo Sheikh, alias Rahim Baksha. All the names are same and one identical person, that is my uncle. That OP's mother's name has been recorded in the voter list of 1966 as Chandraban Nessa Bibi, and in the voter list of 1970, Chandraban Bibi, and other voter list, Chandraban Beva. All the name are same and one identical person, that is OP's mother.
Rita Cross,
OP is the son of my uncle Rahim Box. My uncle Rahim Box had 4 brothers, Jabbar Ali, Rahim Box, Abdul Ghafur, Asiruddin. OP was born at village Salakura, Shialmari. I was born at village Salakura, Shialmari. Due to erosion of river, I, along with my father, shifted to village Vagalamari in 1971. OP's mother's name is Chandraban Bibi. She died. OP regularly casting vote, have landed property. OP has 5 children. OP has 7 brothers, Ansar Ali, Shamsher Ali, Somer Ali, Amjad Ali, Monar Ali, Amjad Ali, Monar Ali, and Toshiron Nessa. Grandfather's name is Khudu Sorkar, and there is no case in the family.
so from here you have seen just now that you have read that DW2, the projected brother of the proceeding, okay, at para
Oh,
para 3, that his name recorded in the voter list of 1970 along with his parents at village Salakura. Right? Then para 3, he says there are 2 para 2 and 2 para 3. Second para 3, which should have been 4 anyway, or 5. That name, their names figured in the NRC of 1951.
Abdul Jabbar.
Then at para 5,
Para 5. My uncle
So it
Rahim
is
Box.
clear from the cross as well as in chief that erosion took place in the year 1971. Because this projected brother's name was in the voter list of 1970 from village Salakura. And he has specifically stated that after erosion,
Voilà.
Prosidi's father went to this village and they lived for Bogulamari.
Voilà.
During cross, he also reiterated that the river erosion took place only in the year 1971. Then how come the name of the projected father of the Prosody and mother recorded in the voter list of 1966 from village
Borkulian Askara.
Borkolia, Aspora? Will you be able to answer? Kindly explain.
My lord. 66.
He has said that yes, my father is the elder brother of Opis father Rohim Box. They are together at Salapura. River erosion took place in 1971. Thereafter, they separated.
My lord.
One fellow went for one particular family went to Borkulia, the other family went to.
My lord, it is a fact that due to erosion, he has shifted the village.
71.
It may be
That is the
70, 71, whatever, maybe, my lord, he,
Kindly answer us. Why the name of Rohim Box and projected
66
father and
Rohim
projected
Box.
mother figured in the voter list of
Borkulia.
1966 and 1977 from number 180 Borkulia, Noskora. Because erosion took place in 1971.
Their family, my lord,
So
was
which one is correct?
71,
Which one is correct?
71, 1997.
As you know, under section 9 of the Foreigners Act, what kind of evidence
71.
wasn't reliable, acceptable evidence? So tell us.
Into voter list. Due to erosion. My lord, here 1971, he says that due to erosion of river, I along with my father,
Actual
along with
translation.
my father shifted to village Bogolamari in 1971. Here DW2, my lord, he along with his family members shifted to Bogolamari in 1971.
That's right.
My lord, it
He
is,
said more Janmo Salakura, Sialmari Gaon,
হয়, yes,
নদী ভঙা বাবে 1971 চনত মই আৰু দেউতা বগুলামাৰী গাঁৱত উঠি আহোঁ। But
it is his family, my lord,
that's true.
my lord.
But it just read at para 5 of that evidence in affidavit of the DW.
DW2, paragraph 5.
Hereafter, my uncle Rahim Box and our residential house and landed property was eroded by the river Brahmaputra.
Brahmaputra.
Then my uncle residential home shifted from village Salakura to village Borkolia, Noskora. And my parents' house has been shifted to village Bogulamari.
Bogulamari. But here it is,
Listen,
here it is not mentioned that
up to 1970, they resided at village Salakura because that is why their names figured at village Salakura. That is very much there. In the
Chalagura
evidence
is
in
there, my
affidavit.
lord. Yes.
So
Before 66. NRC, my lord,
NRC.
NRC at Salagura.
NRC has been proved.
No, my lord, I mean that NRC
The
is
document that is not
1951,
been proved, that is the document.
Chalagura.
So that is the reason we are asking.
They were born at Chalagura,
Yesterday,
my lord,
when they have
and
BW,
landed property was Chalagura.
when DW2 categorically stated that in the year 1970,
His family shifted, my lord. He is along with his father,
he has categorically stated
not with his uncle. It is not stated, it is not
the
clarified.
erosion.
Erosion, that means here it is not mentioned the date, my lord. In the cross-examination, he says that I, along with my family, shifted to Bogalamari in 1971. His uncle may not be shifted or earlier shifted.
Because
my
it
lord.
is
His
clear.
uncle, about his uncle, it is not clear.
He has stated very clearly, my name has been recorded in the voter list of 1970 with my parents at village Salakura. There are 3. And that's an exhibit. So up to 1970, they were there. If it is up to 1970, then how come the name of Ravin Box with Chandrakant Ray figured in the voter list of 1966 at village 180?
Sometimes it happens,
Borkolia,
my lord.
Noskora?
My lord,
We are asking you kindly explain.
my lord. But sometimes it happened, my lord, one person shifted one place to another, but the voter list remains in the earlier village, my lord. It may also happen, my lord.
When the village doesn't exist, how can the name be voter list?
My lord, it may also happen.
It may, we are not on.
But here, my
We
lord,
cannot be on presumption.
so far I understood, my lord, that he has
Mr.
stated that he has, due to erosion, he has, their family shifted.
That's true.
Both the family, uncle's family, his family, yes, shifted from Chalagura to Borgolia, Naskara, my lord. My lord.
Yes, yes.
Lovely. So, 1 নম্বর। Right. Yes, Mr. Chalia.
Yes, Bashir.
Lordship, here there is an opinion by the learned tribunal, my lords, where it has been stated by the tribunal that the petitioner has been declared a foreigner, my lords. If Lordship allows me to go through the opinion, the findings of the tribunal, my lords, I'll be able to present my case in a better footing, Lordship. I will start from page 67 of my writ petition, my lords. Here, the observations of the learned tribunal is there, my lords. I'll like to say. Proceeding in his written statement stated that his parents' name along with two uncle name appeared in the voter list of 1966. Exhibit 1, in the said voter list, Proceeding's grandmother's age shown as 40 years and projecting uncle Jahuddin age shown as 30 years. It appears that mother and son's age difference is only 10 years, which is biologically impossible. In 1970 voter list, Exhibit 2, Proceeding's parents' name appeared along with his uncle. In the set 2 voter list, Proceeding's mother's name appeared as Basiran Nefa. Lordship, here that observation has been made by the tribunal. In the written statement, Proceeding para stated that his mother's name is Basiran Nesa as well as Sabjan Nesa. Lordship, that has been already brought to the notice of the tribunal. Is one and the same person, but a mere statement in the absence of supporting evidence would not be an acceptable explanation of such discrepancy. Proceeding submitted 1985, 1989, 1994, 1997 voter list of his own along with his mother Sabjan Nisha, but in 1966 and 1970 voter list mother name appeared as Basiran Nisa. Hence 1966 and 1907 voter list submitted by the person not trustworthy, my lords. Here they are not doubting the or challenging or the voter list, my lords. They're just saying it's not trustworthy because the names are different. Here, Lordship must be aware, Lordship has seen name discrepancies in these voter lists are a regular error that has been consistently in different cases, my lords. The name discrepancy occurs, my lords. Along with age discrepancy, there's a lot of judgments, and Lordship will also must have seen in a lot of cases where these things are on the basis of that, Lordship, they have rejected the evidence that was produced by the petitioner. After that, in page 68, Lordship, the tribunal has further observed after 1966 voter list proceedings submitted 1997 voter list of his projecting grandmother after a gap of 30 years. 1997 voter list was submitted, but Proceeding failed to explain why Proceeding did not submit any voter list of his grandmother in between 1966 and 1997. Lordship, in this regard, I would like to rely upon a judgment by this coordinate bench of this Honorable High Court, that is WPC 1818 of 2019. In para 46 of the said judgment, Lordship, Lordship, once I can provide a copy of the
It's okay, it is here, we'll get it.
Yes, Lordship. Lordship, here it has been stated in para 46. We are at a loss as how the tribunal could come to this conclusion that the petitioner could not establish his link with his father. The petitioner as well as his father has testified before the tribunal about the relationship supported and corroborated by other documentary evidence which have not been challenged. As regards non-explanation by the proceedee of non-appearance of names of his parents, Nadumia and Aimoni Nessa in the voter list between 1970 to 1993, because of which the tribunal held that the petitioner failed to establish the linkage. We are of the opinion that if the voters list 1965, 1970, as well as subsequent voter list of 1989, Lordship, onwards are found to be unrebutted and not challenged, which clearly show the linkage of the petitioner's father, Harmuz Ali, with the claimed grandfather, Nadu Mia, non-explanation by the proceedee or his father about non-mentioning of names of so and so in the voter list of 1970 to 18 cannot be a ground to disbelieve the voter list which clearly show the linkage. Lordship, if the voter list from the period of 1970 to 1989 could be produced showing their names are proof, these could certainly bolster the case of the petitioner, but certainly cannot have the effect of negating the effects of other voter lists which have been proved and not rebutted by the state. So this observation by the tribunal, Lordship, after 1960, proceedee submitted 1997 voter list of projecting grandmother after a gap of 30 years, 1990 voter submitted by our failed to explain why proceedee did not submit. Lordship, this observation, as per this judgment, my lords, the tribunal has made an error, my lords. Just because he could not produce it does not negate his other voter lists, my lords, where the grandparents' name and the father's name and the mother's name have appeared, my lords. Lordship, here the petitioners, I will be relying on the judgment regarding Lordship because this judgment will cover a lot of facts regarding the petitioner's case. Because here the petitioner is an illiterate, my lords. At that time when they received the notice, my lords, petitioner was not aware of what all documents are needed to be produced in front of the tribunal to prove his case. In the hastiness, whatever he had produced, whatever he could have produced, my lords, he had produced. And then no fresh evidence also, we are not going to bring any fresh evidence, my lords, but this is something which the tribunal has completely disregarded. His previous voter cards where the parents' name and the grandparents' name existed. Now, further, my lords, here in page 68, D.W. Sattar Ali, projecting uncle of proceedee, submitted evidence on affidavit and cross-examined D.W. in his evidence, stated that Mafizuddin Mahizuddin Mahi Diwani is one and the same person. Proceedee has not submitted any documents to prove that Mafizuddin Mahizuddin Mahi Diwani is one and the same person. A mere statement in absence of any supporting evidence would not be acceptable explanation of such discrepancies. It appears from the evidence that proceedee failed to establish his linkage with his parents. Similarly, DW3 Rahman Ali, projecting uncle of proceedee, submitted evidence on affidavit and cross-examined. DW3 submitted 1997 voter list, but after that, no other voter list was submitted by DW3. DW4, junior assistant of RK Go branch DC office Borpeta, adduced evidence. In his evidence, he deposed that Exhibit 3 Jamabandi copy issued from his office, Exhibit 3 Jamabandi copy of 1958 to 65 Patta number 118 old and 122 new of village Mohammadpur. He bought along with him original Jamabandi record of village Mohammadpur Musa Jania. He deposed that Exhibit 3 is similar with original record. He also deposed that he has bought along with him original volume of Patta number 182 exhibit, but he has not bought along with him the Patta number 18 volume original record. He also deposed that in Patta number 1A, Pattada name is similar, but in Patta number 18, Pattada name is not similar. He also deposed that Exhibit 5 was issued from his office. Lordship, if proceedee's name and his brother name mutated in his place, in place of his father, but proceedee failed to submit a death certificate of his father, and the circle officer's mutation order to prove the Exhibit 3 and 5 Jamabandi copy. Moreover, proceedee failed to submit up-to-date land revenue receipt of the land, hence Exhibit 3 and 5 Jamabandi copy submitted by the proceedee not reliable. Now DW5, my lords. Here, Gaubura village Rupa Kusi adduced evidence and cross-examined. Here the Gaubura also came and he was cross-examined also. Exhibit 13 is the certificate and Exhibit 13(1) is his signature. In his evidence, Gaubura deposed that he issued this certificate on the basis of that he knows proceedee and his father. Lordship, the Gaubura has already submitted. He has been serving as Gaubura from the year 1990. He also deposed that he does not maintain any register. On the said certificate, the state emblem is embossed at top of the certificate. This unauthorized use of the state emblem itself renders the certificate inadmissible in evidence, and accordingly, his certificate is discarded. Therefore, Exhibit 13 certificate issued by the Gaobura where the state emblem is embossed at the top may not be accepted as a valid and acceptable document. Here, Lordship will see, Lordship, here the Gaobura, he himself physically present, he was cross-examined, but he had already stated that this man is a resident of the village. He identified the petitioner. He had identified his father even. But on the basis of the certificate that there was a state emblem, the tribunal rejected the certificate. Now, Lordship, here at that moment when the tribunal proceedings were going on, they were not aware of how the documents have to be presented. However, the Gaobura personally came and he identified the two people. So, okay, the certificate was rejected, but the statement regarding the statement, Lordship, there was no observation by the tribunal regarding the statement that they have not rebutted. If the certificate might have been not issued as per law, Lordship, but the statement of the Gaobura has to be taken into account because who will identify in a Gao whether these are the residents, whether these are the people, whether he is the father, who is going to identify that? That is the Gaobura, Lordship. Now, on the basis of a technical, Lordship, legal technical, that certificate has been rejected. Exhibit 14 name correction affidavit. This is self-serving affidavit sworn belatedly has hardly got any evidentiary value. Although election officer submitted a report of the authenticity of the voter list, which was submitted by the proceedee, but it does not prove that the name contained in the said voter list indeed his parents. That dispute has always been there. The documents submitted by the proceedee are not at all sufficient, reliable, and trustworthy. Proceedee failed to prove the linkage with his parents. Mere filing of some documents and picking up any name from such documents so as to establish relationship is not enough. The documents filed by the proceedee cannot be taken as legal evidence to confer Indian citizenship. As per provisions of Section 9 of the Foreign Act, the onus of proving that he is a proceedee is a citizen of India and not a foreigner lies upon the proceedee. Having regard to the evidence adduced by the proceedee, it cannot be said the proceedee has discharged his statutory burden under Section 9 of the Foreigners Act 1946. In view of the discussion referred above and on the basis of the evidence and documents available in the case records, the reference is answered in the positive, declared proceedee is a foreigner within the meaning of Section 2A of the Foreigners Act 1946, having illegally entered into India, Assam, after 25/3/1970. Copy of the order be sent to the Deputy Commissioner Election Borpeta for information and for deletion of the name of opposite party if enrolled any voter list in Assam and also for cancellation of ration card and all other beneficiary schemes under the government if any issued in the name of opposite party immediately. And then there's the order, Lordship, in view of the opinion that proceedee is a foreigner of post 25/3/1971. The reference is answered in the positive and against the proceedee declaring Noor Islam, son of Amiruddin of village Mohammadpur, PS Borpeta, district Borpeta, is a foreigner as alleged in the reference case. The Superintendent of Police B Borpeta shall ensure that the proceedee second party is arrested and detained in the detention camp till his deportation to his country of origin. The Deputy Commissioner Borpeta is directed to take appropriate action in the matter towards deletion of the name of the proceedee second party from the voter list, if any. On the last date, Lordship had raised another query whether the name of a minor can be there, can be there in the Jamabandi copy, my lords. And here, Lordship, I have from what I have gathered, Lordship, from the Assam Land Revenue Manual, Lordship, there is no bar, my lords, for a minor whose name can be there in the Jamabandi, my lords, but he's barred from selling that said land until unless he attains majority by the Indian Contract Act, my lords. So name that right can be there, my lords, but the minor cannot sell that land off, my lords. He's barred from selling the land off. This was a query raised on the last date, my lords. So the order of the tribunal also, Lordship, it has been passed very mechanically, where no proper explanation has been given regarding the observation. They have just discarded all the evidence and has been passed very mechanically without appreciating all the facts of the case.
Mr. Chaliha, take your seat. Kindly show us the link one by one.
Lordship. Okay, I'll start with page number 20, Lordship.
Hmm.
Here the name of my grandfather Mufizuddin appears.
Ah.
Along with the name Sajan Nesa is appearing, my lords. Underneath Mufizuddin, name of Sajan Nesa is there, my lords.
Hmm.
Sajan Nesa will be my grandmother, lordship. And then in serial number 90, second last name from the bottom will be Basiran Nesa.
Hmm.
That is wife of Amiruddin, my father. That is voter list of 1966, lordship. Then there's the voter list of 1970, lordship. Here the name of my father is appearing, my lords. In page number 22, I have the type copy is there, my lords. Page number 23 will be the voter list, my lords. Name of my father is appearing, Amiruddin. My grandfather's name in front of him, Mufizuddin. Abdul Barak, who is the brother of my father. Then there is again the name of my mother is there, Basiran Nesa, my lords. Wife of Amir. That is the voter list of 1970, lordship. After which, lordship, in 70. Here 19. Then in page number page number 32, my lords, that is the voter list electoral roll of 1985. Name of my mother, Sabjan Nisa. Along with my name, the petitioner's name, Noor Islam is coming, my lord. Page 33. Husband's name, Amir. Lordship, we have stated that the name has been wrongly recorded. My father, in the evidence also, we have stated in a written statement also, we have stated that Amir, that has been wrongly typed as Amir. It is Amiruddin, my father's name. Because Lordship will see if I can draw the link because Lordship in the 1966 voter list, name of my mother is appearing Basiran Nisa. She's 29 years old. 1966. 1985 will be 19 years after. So Lordship will see the age. she was 29 in 1966. Plus 19 will be 48 in the year 1985, my mother. That is, but in that we have also stated that Noor Islam, that my age has been wrongly shown as 28, whereas it should be 23 because I was born in the year 1963, Lordship. That we have stated. Now, Lordship will see how the electoral roll. Now, in the year 1994, Lordship, this is 9 years after the 1985, 1999. Page number 37. The same Sabjan Nisa is shown as 50 years old. And now my age is shown correctly as 30. Husband name is Amir. It's and then there is the year 1997, Lordship, voter list, where Shabjan Bidwa. That is page number 1990s. Yes, in this 1997 voter list, my wife's name is showing, Lordship. I apologize. But I have stated in my evidence that my name has been found in the same voter list as doubtful, my Lordship, 1997. And the certified copy of the voter list is present in the records, Lordship. Here in my writ petition, I have not annexed it, my Lordship.
Anything else?
No, for the linkage, Lordship, that and then I have the Jamabandi papers, Lordship. That is which my grandfather had given to me, Lordship, where the question arose whether a minor's name can be there in the Jamabandi, my lords. Can it be mutated, my lords? That is when that query arose, which as per there's no bar on the name of a minor where his name can be mutated. He's barred from selling the property, my lords. That is the only bar. So name can appear, my lords. So my grandfather had already given me a plot of land that we had produced in the learned tribunal, my lords.
Which is your correct but here?
1963, lords. I have stated that in my
1960.
lordship. 1963, my lords.
And what else?
Yes. Here, lordship, here I'm relying on this judgment passed by this honorable court in Hyder Ali, lordship. In Hyder Ali, para 42. This is regarding this regarding my
Hyder Ali citation, please.
lordship. Here I do not have the site. I have the WPC number, lordship.
Please, sir.
Yes. WPC number is 1818-2019.
That you have cited, para 46 earlier you have cited.
Yes, lordship.
Now para 42.
Para 42, lordship. In lordship, if lordship will allow me to read it, lordship.
Yes.
Yes. On proper analysis of the aforesaid observation of Honorable Supreme Court, the following aspects emerge. In order to establish one's citizenship, normally he may be required to give evidence. his date of birth, place of birth, name of his parents, their place of birth and citizenship. However, the Supreme Court nowhere states that the aforesaid fact must be proved only by documents. Dear Lordship, in my case, the Gaubura who identifies the people, the residents of that particular village, my lords, that is his sole role. His statement, it is not like he only gave it in written, my lords, he was present. There was a deposition. His certificate was discredited, but there was no observation by the learned traveler regarding the statement where he identified both of them, the father as well as the petitioner, my lords. Regarding that, it was totally disregarded. Now, here it has been observed, Lordship, here. However, the Supreme Court nowhere states that the opposite fact must be proved only by the expression used is normally he may be required to give evidence. Thus, it is not mandatory to prove all this to show that he is an Indian citizen. These are, however, relevant facts if one can establish beyond doubt that he is a citizen of this country. Yet he may be able to prove his citizenship by other evidences as well. Here, my lords, because of a mere technical mishap from the Gaubura where he used the seal, his statement has been also disregarded, Lordship.
Mr. Salia, assuming a situation, a person, you know a person of your locality,
Lordship.
and you've been asked to adduce evidence. And you have stated before the court, that is, I know Mr. A. He is son of X.
Lordship.
Now, in a provision under the Foreigners Act, is that statement will be enough
No,
as because you know him? Will that be enough? In the context of section 9 of the
Lordship. It has to be further substantiated with some documentary evidence, Lordship.
Yeah.
But Lordship,
look at the evidence of the Gaumura.
yes, Lordship.
What he has stated.
Lordship, the statement I have annexed in.
Let cross what he has.
Yes, Lordship. Abdul Karim, yes. Lordship, page 60 is the type copy, Lordship. Yes. The second party of this case, Noor Islam, I know him personally. I have given a certificate in the name of the second party, Exhibit 13. Lordship, that has been disregarded. In this certificate, Exhibit 13, my signature is there. I have given the certificate to the second party because I know him from his childhood. The second party, Muhammad Noor, is a resident of this village. I know the grandfather and the father of the second party. The second party's father has been residing in this village since 1966 along with the second party, Muhammad Noor. This is here stated in this cross, Lordship. I became village headman Gaubura in 1990. I am the village headman of the village Rupakusi and Muhammadpur. The name of the grandfather of the second party is Mahesh Diwari. I have forgotten on which year the grandfather of the second party had died. I have forgotten when the father of the second party had died. I have not maintained any register. It is not a fact that I have come here to depose false evidence.
So if he doesn't maintain a register, only by
Lordship,
knowledge
but
will be enough.
here,
Section 9 of the Foreigners Act.
yes, Lordship, yes. But Lordship, he has the role. What is the role of a Gaubura, Lordship?
That is the reason we're asking you. Under section 9, his mere statement will be enough.
Section 9, if in any case not falling under section 8, any question arises with reference to this act or any order made or direction given thereunder, whether any person is or is not a foreigner or is not a foreigner of a particular class or description, the onus of proving that such a person is not a foreigner or is not a foreigner of such particular class or description as the case may be shall, notwithstanding anything contained in the Indian evidence, lie upon such person. Now, here,
So it's a non-essential clause, right? Under the Evidence Act.
Lordship.
So how do you prove? The
Lordship,
person is not keeping any register. He only knows him, that's all. Is that sufficient to accept that will it be a cogent, reliable and admissible
But-
evidence under section 9
No.
of the?
Yes, Lordship, but in certain cases, Lordship, here, the same judgment which I am relying on,
No,
Lordship,
no, maybe that is why we are asking you. Kindly
when otherwise
place
the,
us
yeah.
by praying, but placing a judgment. We are not aware in that judgment what is there.
yes, Lordship, yes.
Background of that case is whether it is similar, the facts of that case is similar to this case.
Yes, Lordship, here
Just
the,
don't pick up a particular paragraph of a judgment.
yes, Lordship, Lordship. No, no, Lordship,
Tell us
because
whether the facts of the Hyder Ali's case is similar to this case or not.
to a certain extent, here, there he had,
So
he,
here is a case that you are saying that the Gambura have proved him that he is his father and he is grandfather.
yes,
He became Gambura India 1990.
yes,
And earlier part that his grandfather, his father, or he is from childhood. These are all basically from his knowledge.
yes, Lordship.
Now, if it is from knowledge, what will be the evidentiary value?
No, otherwise, Lordship, the role of the Gaubura in total,
Is it knowledge or some record?
it is from knowledge, Lordship, that he has only stated, Lordship, he,
So if it is from knowledge, what will be the evidentiary value?
Lordship, his statement, mere statement, Lordship,
That's what, as he is his Gambura from 1990 only.
1990, Lordship,
He
so
doesn't know when his father expired. He doesn't know when his grandfather expired.
his,
He should have remembered.
he,
He should have remembered he's the Gambura.
Lordship, at that Lordship, maybe at that moment when the examination, he was
So
not,
basically, Mr. Salia, you have to explain why this is an admissible evidence and if not, why it is not an admissible. Tell us why it is admissible evidence under section 9 of the Foreigners Act.
Lordship,
Any person can come forward for a foreigners tribunals and I know him since my childhood. He is his daughter, his son, his grandson.
Yeah.
Will that be enough?
no, Lordship, that, some, but Lordship, here,
Whether from that knowledge is sufficient or it has to be with certain things along with the knowledge. What is the requirement under section 9 of the Foreign?
that, he has to, there has to be
In
some,
that case, what is the need of the tribunal? What is the need of the tribunal?
to cross-examine.
So that is the reason we are telling. What is the need of the tribunal? They say, yes, Mr. Satyan Sat is recorded. He is a Gambura. He said he knows him personally. He is a son of this fellow, grandson of this fellow, and he is an Indian citizen. Finish. What is the requirement?
No, but Lordship, here, in my humble submission, the role of the Gaubura is such,
So without even keeping a record, Gambura, since Gambura is saying, I know him personally, he is an Indian.
village, Lordship, if I may read para 48 in this, my lord, there, that regarding the role of,
Read it again. Read it.
no, para 48, Lordship, this is,
Yes, before us, we have read, you did it. Read aloud.
oh, yes, Lordship. In para 48, Lordship, this is only regarding the Gaubura, Lordship. We have also noted that the petitioner had examined one witness, namely Pushpuram Medhi, who was the Gaubura of Bar Simla village of Borpeta district. He appeared before the tribunal on being summoned along with counterfoil of certificates which were exhibited as Exhibit 1 and Exhibit A. He stated that he issued the certificate to Haider, son of Harmuz Ali, and Exhibit J to Harmuz Ali, son of Nadu, and he also identifies the signature appended on the said documents. He also stated that the said two persons, namely Haider Ali and Harmuz Ali, were residents of his area. He stated that he issued two certificates after proper verification. His evidence was not challenged nor shaken during the cross examination. However, there has been no discussion about the said evidence of DW4, the Gaubura, in the opinion given by the tribunal. Actually, a similar, this is the observation by the honorable court regarding that, Lordship. This is nothing else, Lordship. We accordingly, for the reason discovered, do not agree with the conclusion.
Now just see at page 57.
Yes,
Paragraph 57.
Para 57. Para 57, Lordship, of the for the reasons discovered, the present petition in law for setting aside the impugned order dated 31/2019 passed by the learned members, Foreigners Tribunal 3, Borpeta in FT case number so and so of 13 by holding the petitioner to be Indian, not a foreigner.
What is the law laid down by the apex court in these circumstances when somebody's evidence is not discussed? Matter has to be remanded back or not?
Remanded, yes.
What is the finding in 57?
Sorry, Lord, sir.
What is that para 57?
Lordship,
They
here,
have been remanded back. That's the law laid down by the apex court.
yes, Lordship. Lordship, I am,
See, that is the reason we are telling you. What are the evidence to be accepted by the tribunal? If some evidence is placed before the tribunal, and if it is not proven reliable and admissible, then only the cross is required to be done by the state or objected to be by the state. Till then, not required.
here,
Any
Lord,
statement made from knowledge is sufficient before the tribunal to prove somebody's citizenship.
no,
Yes,
Lordship,
it is the finding of the apex court.
no.
Then-
Here, Lordship, that is a mere
See,
stand.
remember one thing, we are sitting here in certiorari, not in any other reads or portento or mandamus or anything.
Lordship,
You can only say an order of the tribunal is good or bad. If we see that order of the tribunal is bad, what we should do? Can
remanded,
we declare?
no. No, Lordship, here, under,
Anyway, kindly tell us one thing. You said you are born in the year 1963.
Lordship,
What is Annexer 4? What is Annexer? Was it
Lordship, this-
exhibited?
yes, Lord, it was in the evidence.
Why this was exhibited?
Lordship, here, in my evidence, Lordship, in page 49, I have stated, Lordship. It's para 12, that in the year 1958 to 65, my grandfather and my father owned and possessed a plot of land, White KP Patta number 118, New 112, at village Mohammadpur, Moza Jania, PS Borpeta, district Borpeta, in the state of Assam. After the death of my father, the said land was muted to my mother's name for the same, and my grandfather's share has been possession by his legal heirs and also have been paying revenue. Exhibit 3. That my Lordship, here he has mentioned himself that I was not attained 18 years of age for the year of 1969. My grandfather, White, registered sale deed was given a plot of land measuring 3 biga, White KP Patta number 182, Dag number 45 at village Mohammadpur, Musa, Jania, PS Borpeta, district Borpeta, in the state of Assam. Said land was muted in my name 1975. At present, the said land is under my possession and I also have been paying revenue, my lords. So this has been exhibited because he's staying over there and then he's staying there with his mother. And then he's claiming that although he's claiming that he's paying the land, paying the revenue, land revenue, Lordship, but admittedly here we have not been able to produce.
What is the statement of the person from the collector who?
Yes, Lordship, that I read, Lordship, that is in page number, yes, page number 68, second last para, Lordship.
Yes.
DW4, page number 68 of my writ petition, Lordship.
68.
Yes.
68 is the order.
Yes, Lordship, there,
His evidence has not been there.
that is in his evidence, I read it from his evidence only, Lordship. Page number.
Read from here. There is a reason behind that. You have not annexed there.
Lordship, I have, these were the only details which I had, Lordship. I have,
Page number 58.
page number,
Five.
Yes.
Hmm.
Page number 58. I'll read. I have come to depose on being received the summon from the court. I have been working as assistant register Kanango at DC office, Borpeta. The area of exhibit 3 Jamabandi was issued from our office. The area of exhibit 3 Jamabandi in 1958 to 65 of Patta number 118 old and 122 new of Mohammadpur village. I have bring with me the original volume. The area of Jamabandi of exhibit is matched with the original volume. I have bought today the original volume of Jamabandi of Miadi Patta number 1958-65 new 182 of Mohammadpur village Muza Jonia. Though I bring the original volume of Patta 182, but I do not bring the original volume of Patta 18. In Patta number, the name of the aforesaid is matched, but in Patta number 18, it is not matched. Exhibit 5 has been issued by our office.
So he said in patta number 182, the name of the aforesaid matched,
Yes, Lordship.
but in patta number 18, it is not matched.
Yes, Lordship.
But he didn't bought the original
Yes, Lordship.
part of patta number. Now, please come to page number 20. The vernacular is at page 21.
Yes, Lord.
Read the name at serial number 85.
Mufisuddin.
This is a voter list of 1966.
Yes, Lordship.
Then Sajan Nisa.
Sajan Nisa. Yes, Lordship.
Then
Jaharuddin,
Then
Amiruddin,
then
Abdul Barak, A. Barak,
then
Basiran Nisa,
then
Surya Bhanu Nisa.
then page number 22.
Yes, Your Lordship. Here it's Amiruddin,
Hmm.
followed by A. Barak
Hmm.
and Basiran Nisa, Lordship. That is 1970 voter list.
Right. Then you come to page number 24. Number
24.
1.
Yes, Your Lordship.
Page number 24. The English translation is there.
Yes, Lordship.
The vernacular is also there.
Yes, Lordship.
His name is there. That relates to old patta number 118, new patta number 122.
Yes, Lordship.
Whose name is there at 1?
It's Mohizuddin Sheikh.
Mohi.
Mohisuddin Sheikh.
And what is the name of your grandfather?
Mohiuddin. Mofizuddin, my lord.
Mofizuddin. And what is the name of patta number 1 here?
It is Mohisuddin, Lordship.
Mohizuddin. Now, what is the patta number 2? Whose name is there?
It is Lordship Shri
Zasur Ali Sheikh.
yes, sir. Jasur Ali Sheikh, son of late Humani Baperi.
Now, please come to page number 20.
Page number 20, Lordship.
Serial number 3.
Yes, sir. Joharuddin,
Son of.
Mofizuddin.
Then serial number 3 at page number 24.
Yes, sir. Lordship. It shows Shri Tajur Ali Sheikh.
Son of.
That this son of is not
It is
written.
there, but you have not written here.
No, page number.
Both 2 and 3 are a son of.
Yes, Lordship. Son of late Humani Baperi.
It's not Kumani, it is Gumani.
Humani.
Geo.
Gumani.
This Sukur Ali Sheikh is his name in the voter list of 1966 along with Mofizuddin.
Poorly said.
Is it there in the voter list of
No,
66 or 70?
no,
It's
no.
not there. Now, serial number 4,
Here is Sajan Nisa, wife of Ami Sheikh.
Sabjan Nisa.
Sabjan Nisa.
If it is in the voter, in the Jamabandi of 1958 to 1965,
Sajan Nisa, yes, sir.
Sabjan Nisa, wife of Amir Sheikh.
Yes, sir.
Now, is there any Amir Sheikh here prior to deleting the name of Amir Sheikh?
No, no, your lordship.
See, if it had been by inheritance, you said your father
My
and your
grandfather.
grandfather had
Yes.
joint property.
Yes,
Now, the name of your father should have been struck off,
lordship.
and in his place, he could have, by inheritance, you could have acquired that land, it is in your name or in your mother's name. Your mother's name would have come there.
Yes, lordship.
Now, here it is directly Sabjan Nisa,
Yes, lordship.
wife of Amir Sheikh. But you have said that your father and your grandfather
Yes, sir.
had land.
Yes,
So was when your mother's name was incorporated by right of substitution, right of inheritance. Where is that order passed by the circle office?
so those documents. Okay.
Now, let us assume this document has been placed before the tribe.
Lordship.
Is it an acceptable evidence? You have read the judgment, right?
Yes,
You have
lordship.
said document has been placed. It has to be accepted. Now tell us.
It has to be proved, lordship, before.
Now tell us. The concerned person from the settlement officer also came here. The names, whatever is in that particular patta number 118,
Yes,
new number 122, names is similar as that in the
yes,
record. Whether names are there.
yes, sir.
What is the name of Sabjan Nisa, wife of Amir Ali? Was your mother or was your father? How will you have proved it? Because, first of all, if name of Amiruddin Sheikh along with Mofizuddin Sheikh would have been there.
Yes.
And their names have been struck off, that would have been different issue. You see this particular Jamabundi, neither the name of Mohizuddin, because your grandfather's name is not Mohizuddin Sheikh. Neither the name of Mohizuddin has been struck off, nor your name of your father has been.
Lordship, Mohizuddin, we have stated in our written statement, Mohizuddin.
Show us by which order of the circle officer name of your mother has been incorporated. You come to page number 26. Particular.
Yes, lordship.
See, serial number 2 and 3, their names have been struck off.
Yes, your lordship.
Serial number 5, 6, it has been struck off.
Yes, lordship.
8 has been struck off,
Yes, lordship.
right? Why? Why? Why it has been struck? Why their names have been struck off from the Sodor Jamabundi? Why? Either that man has sold that land or someone on his death, the right of inheritance, names of the legal heirs of the deceased person has been incorporated. There has to be an order.
Yes.
By which particular order name of Amir Sheikh has been struck off and Sabjan Nisa has been incorporated in the Sodor Jamabundi. Since the name of Mohizuddin Sheikh and Srimati Sabjan Nisa is there in the Sodor Jamabundi,
Lordship.
without striking off the name, that means what? Mohizuddin Sheikh and Sabjan Nisa the particulars of that land
Yes,
for the period of 58 to 65. If it is from 1958 to 65, Amiruddin, son of Mofizuddin,
yes.
wife is Basirun Nessa, not Sabdan Nessa.
Subjan, Subjan,
Not Sabdan Nessa, because in the voter list of 66 and 70, it is very clear.
Lordship, Subjan and Basiran Nessa are one and the same person.
I cannot say here.
Lordship.
Show us that prior to that, it is Mofizuddin, not Mohizuddin in the Saban Jamabandi.
Yeah, here,
You have to prove.
yes, Lordship.
By mayor making a statement will not do, Mr. Saliha.
Yeah, no, Lordship. Here,
True.
that,
That is the reason it is what is happening here. You just pick up from one thing, one Fatah Jamabandi, for another from the voter list.
yes, Lordship.
If it is there, then where is the difficulty for you to show after 1970? Why only the voter list of 1985? What happened in between from 1970 to
Yeah,
1980?
those,
They vanished.
no, Lordship, here, maybe,
That is the reason. If you would have shown that, yes, prior to becoming a Sabjan Nessa, Basirin Nessa was there in the year 1973, 74, 75, whatever they put. Anyway, anything else you like to show? Now, second
No.
part. What is interesting part is you say you have been born in the year 1963.
yes, Lordship, that we have,
You have exhibited a document which you have not annexed here.
yes, Lordship here, yeah.
That is exhibit 4. For your information,
Yes, Lordship, I have not gone through the report.
one Mahidevani, son of Gumen Haji, on 23rd of October 1969,
Yes.
donated a land, a parcel of land, to one Nur Islam Mia,
Yes.
Nur Islam Mia,
Yes, sir.
son of Amir Uddin,
Yes,
which year 1969,
90, yes,
and saying what you know, that this Nur Islam Mia, son of late Amiruddin, looked after this Mahidiwani and took his full care,
yes,
took his full care. And being satisfied, he donated a parcel of land measuring around 3 bigha
yes, Lordship.
something to him. First of all, in the year 1969, he was hardly 5 years. How a minor could have looked after the man who have donated the land,
Lordship.
number. And saying that Nur Islam Mia's father was late. If he was late in 1969, then how come he was alive in the voter list of 1970? How come he was alive in the voter list of 1970?
Lordship, 19, that we have stated in a written statement that though the father had expired, his name has been there in the voter list. That we have, Lordship, we have.
Then which year your father had expired?
Then 1969, as per
He did not say anything. 1969, his father would have looked after his alive.
Amiruddin, Lordship.
Amiruddin, that is the reason we are asking you, when did he expire?
Lordship, here in the opinion of the tribunal also, it is
That is why in the apex code, the constitution bans have clearly mentioned, if it is under the Foreigners Act, the
So
evidence
that-
have to be reliable,
yes, Lordship.
cogent and
The
admissible.
death certificate has not been annexed. Lordship, here
Many
in 60,
things that, see, why did the constitution bench pass that judgment? Because probably at that point of time, it's 1960s judgment.
yes, Lordship.
It was only partition took place and a matter relates to a person from Pakistan who entered into territory of India. In that particular matter, why the constitution bench have decided in that manner? Can we go beyond the observation made by the constitution bench?
No.
That is why we are asking you. When matter relates to the Foreigners Act, it's a non-necessary clause section
Yes.
9 and above that, just mere producing an evidence will not be enough. It has to be cogent, reliable and admissible.
Lordship,
It is the duty of the person concerned to prove all these three, that this is the evidence, this is acceptable, this is reliable and this is cogent. You have to prove it.
my only humble
See,
submission,
basically, many judgments have been passed.
Yes.
We are not saying anything,
Lordship.
but can we go beyond the constitution then?
No, Lordship. Here I am just simply asking for a fair trial.
You have placed here the, not you, Mr. Chalia, the proceeding have placed many documents.
Yes, Lordship.
But how he have proved? Mere placing a document or mere placing an evidence will not be enough.
No, Lordship,
It is also his bounded duty to show under section 9 that this kind of evidence, which just is simply cannot occur.
here, my only prayer will be to remand the matter so that I can.
Why question of remandment
Lordship,
doesn't
the-
whether the tribunal's order is good or bad. To that
Yes.
extent, we will limit to that because that is our.
Yes, Lordship. So that
Come
the.
back at 2.
Oh, Lordship.
Anything else you like to add, Mr. Saliha? You relying on Hyder Ali? Sirajul Islam? (2020) Okay. Yes, Mr. Paying, will you play?
Well, let's hear your lordship may kindly see. The petitioner is trying to bring the linkage on the basis of the Malad voter list of 1985. Page 32, 33. This is the voter list of 1985. Here as per the petitioner, my lord, the Sabjan Nasa is the mother, and this Amir, page 33, my lord, Amir is the father, and petitioner is, my lord, listed along with Sabjan Nasa. So, being son of Sabjan Nasa, he is also a citizen of India. That is the claim, my lord. That is the only document, my lord. Now, if we see, my lord, the voter list of if we compare this voter list of 1960s and 1985 along with the voter list of 1966 and 70, your lordship may kindly see 1966 first voter list is at page 21, my lord. Page 21 is the voter list of 1966. Here, my lord, who are the voters, my lord? Your lordship may kindly see. This is the first voter is Mofizuddin, son of Gumani, aged about 60 years. Then Sajan Nessa, Mofizuddin, 40 years. Zahuruddin, Mofizuddin is 30 years. Amiruddin, son of Mofizuddin, is about 20 years, 25 years. Then Abarek, Mofizuddin, 22 years. Then, my lord, serial number 90, Bosiron Nessa, Amiruddin, that means wife of Amiruddin, and aged about, this is probably 21, my lord, 21 years. So, the petitioner is trying to, my lord, say that the Basiran Bibi is Basiran Nessa is the mother, and in 1985, this Basiran Nessa has somehow become, my lord, subjan nessa. And this Amiruddin, who is in 1966 voter list, son of Mafizuddin, is about 25 years, was his father. My lord, if we compare this voter list along with page number 23 also, my lord, that is voter list of 1970. The 70 voter list and 66 voter list, the projected murder is in the same name, my lord. There is no discrepancy in that. Both the voter list, my lord. This Basiron Nessa, 107 is Basiron Nessa, is it about 28 years? And earlier, my lord, the page serial number 9821, page 21 was Basiron Nessa, is it about 21 years? So there was no discrepancy in both the name prior to 1970. Now, because the entire issue comes after 1971, the cutoff year is 1971, prior to 71 and after 71. So we have to compare both the documents in two manners. Compare the first with prior to 71 documents and after 71 documents. So this link has to be there with 71 documents or 66 documents, the 89 documents. 85 documents. 85 is totally different. By no means subjan, the Basiron can be construed or read as subjan. It's total change, total change of name. And from the evidence in record, my lord, there is not a single evidence brought by the petitioner that this subjan nessa and this Basiron nessa of 1966 and 70 and the subjan nessa of 1985 is the same in one person. There is no evidence to that effect. The name changes only after 71. Only similarity is, my lord. Only similarity in the both the document is the name Amir, not even Amiruddin, because in an earlier occasion it was Amiruddin, son of Mofis. Here only similarity between the voter list of 1966 and this 1985 is only Amir. All others are different. So we cannot say, my lord, this subjan nessa is the same Basiron nessa of 1970, and so the petitioner failed to establish that he is the son of Amiruddin of 1966-70. This is the only linked document. Thereafter, my lord, and if we compare the age also, my lord, in 1985, this subjan is 48 years of age. And if he was 48 years in 1985, her date of birth will be sometime in 1937. So, but if we see the voter list of 1966, my lord, the age was 21 years at that time. And if we calculate her date of birth will be sometime in 1945. So there is a my lord, difference of about 7 to 8 years, not 1-2 years, my lord. Now, thereafter, my lord, the subjan is continuing in 1989. In 1994 also it is subjan nessa. In 1997 also it is subjan vidhoba. One thing, my lord, so long, my lord, till 1994, it was subjan, 94, it was subjan nessa, my lord. It was subjan nessa, and only from 1997, it is subjan vidhoba. Your lordship may kindly note down that, because, my lord, from the WS, what I have seen, my lord, there are two statements in the WS with regard to the death of his father, of the petitioner, my lord. It may be wrong also, but I don't know. Your lordship may kindly see page 42 in the WS. Because this relate to my lord voter list of 1997 and 94. Because in para 12 of the voter list, my lord, WS, page 42, he has given a statement that though the opposite party's father demised in the year 1969, his father name was not cancelled in the voter list of 1970. That means the father, as per this statement, father died in 1969, prior to 1969. Now your lordship may kindly see in the same WS, para 23, mal.
Can you read?
Para 23, it is said, the opposite party's father demised in the year 1996 at village Mohammadpur at own residence. Why I am pointing out this, my lord? Again, this relates to voter list of 1997 because prior to 97, it was Nessa. This Sabjan Nessa. After 97, it is Sabjan Vidhava. From 97, it is Sabjan Vidhava. So this may also be correct. The statement of para 23, my lord. The opposite party's father demised in the year 1996. It's a positive statement, single line statement, my lord. So, what my submission is that, my lord, this may be of a different persons. The later documents of 1985 are of different persons. So the petitioner could not, my lord, bring evidence to rule out that these are not separate persons. This statement creates more doubt on that, my lord. Para 23. Then he brought a voter list. Then he relied on the documents. That is the Jamabandi copy of my lord, page 24, my lord. 24 is, in my humble submission, is no way related to the petitioner, nor to his parents, my lord. Because your lordship may kindly see the page 24. This is the Jamabandi copy of 11118, my lord, of dark number and a patta number. And it's admitted fact, some Mahisuddin Sheikh was there. But the grandfather of the petitioner is Mafizuddin. As per his statement.
Grandfather.
Yes, grandfather. And this Amiruddin, his father is nowhere there, my lord. Amiruddin is nowhere there in the said page 24 documents. No, the Sabjan Nessa. Sabjan Nessa is not there. Sajan Nessa. Sajan Nessa. This is Samir led Bezuddin Sheikh. Habezuddin Sheikh.
Who?
My lord, page serial number 7 at page 26, my lord.
Both way is not correct.
Yes.
If you see, two things you have to see. First is serial number 4
Yes.
is Sabjan Nessa.
Sajan Nessa.
Come to the vernacular one.
Yes. Sabjan Nessa.
Now Sabjan Nessa husband is
Amir Sheikh.
He
Amir
is
Sheikh.
alive. My
Amir
dear,
Sheikh is alive.
He is alive. Then serial number 7, Sajan Nessa,
His husband name is led Habezuddin Sheikh.
Hafizuddin Sheikh.
Sajan Sheikh. And my lord, the projected father is not Amir Sheikh, my lord.
Not Amit,
It is Amir Uddin.
Amiruddin. No, in fact, the father is also not there. It is
Yes.
Mohizuddin. If you
Yes,
read-
Mohizuddin.
But their father is Mofizuddin, grandfather is Mofizuddin.
Yes, grandfather is Mofizuddin, father is Amiruddin. So nobody is there, my lord. The names are Mohizuddin in the page 24, 6, my lord, Mohizuddin, Sabjan Nessa. In fact, if we see, my lord, the voter list of 1966, one Sajan Nessa was there, who was probably the wife of Mofizuddin. In 66 voter list, my lord. Serial number 2,
Yes.
Sajan Nessa was there. So wife of Mofizuddin. She is also not there. So Sun Bhanu. So neither the parents nor the petitioner's name is there in the voter, my lord, this document of at page 26, my lord. And my lord, the next document, jo my learned friend is relying, my lord, the exhibit 4, which is not my lord, annexed here in the present list, present writ petition, my lord. What I have, my lord, heard from the, as your lordship has read out, the land was donated by one Mohi Diwani. Mohi Diwani in 1969 to Nurul Islam Mia, son of Amir Uddin, for the purpose, my lord, as he looked after the, my lord, look after Mohi Diwani. I don't know, my lord, whether it is a registered deed or not. Probably it is not registered.
No, it was registered.
It was registered.
It is a gifted by one Mahi Diwani.
Mohi Diwani. This is no way related to Malat Mofizuddin, the grandfather of the petitioner.
Given to one Nur Islam Mia,
Nur Islam Mia.
son of late Amir Uddin.
Yes.
It says, তুমি মোর মৃত লরা আমির উদ্দিনের লরা মোর নাতি হোৱা মোর নাতি হোৱা তুমি মোক আদৰ যত্ন কৰা শুশ্ৰূষা কৰি থাকা তোমাৰ আদৰ যত্নত মই সন্তোষ পাই তফচিল বৰ্ণিত 3 বিঘা R মাটি তোমাক দান কৰি দিলো দান কৃত মাটিৰ মূল্য 500 টকা দানকৃত মাটিৰ পৰা মোৰ যাৱতীয় স্বত্ব ৰহিত হৈ তোমাত বৰ্তিল তুমি আজিৰ পৰা মোৰ স্বত্বহে ৱাৰিছ স্বত্ব ও দখলে দিয়া পাৰ হৈ মোৰ পৰিৱৰ্তে উক্ত মাটি তোমালোকৰ নামত নামজাৰি কৰি লৈ দান দিছিল okay then interesting part is there the same patta but this patta has not been proved.
Yes.
As you have seen that the concerned officer from the settlement office, they did not got the record of this particular.
Doc number 18.
Total land was 8 biga, 4 kotha, 15 lasses. Mohammadpur village, Doug number 45, Patta number 182. Altogether, 8 biga, 4 kotha and 15 lasses. And out of that, 3 bigas of land. Now, interesting part is there in that record, if you see that page. That is why we ask Mr. Saliha to reply. Now, in this particular land document, which has been annexed here, you'll also see come to page number 29. Got it, page number 29? Then the remark column, the last remark column.
Sitar,
চিঠাৰ উপপতি সমূহৰ 21/12/94 or it is 74, I don't know. It should be 74 only.
yes, bro. Yes.
21/12/74 ইংৰাজী তাৰিখৰ হুকুম মতে
Koridor,
খৰিদ্দা দখল সূত্ৰে, this is not উত্তৰাধিকাৰী,
yes, bro.
খৰিদ্দা দখল সূত্ৰে 45 নম্বৰ ডাগৰ 8 বিঘা 4 কঠা 15 লেচা জমি ও জমাত পট্টাদাৰৰ স্থলত শ্ৰী জহুৰ উদ্দিন পিতা মহিজুদ্দিন, শ্ৰী নুৰ ইছলাম পিতা আমিৰ, শ্ৰী বাসুমিয়া পিতা মহিজুদ্দিনৰ নামজাৰি কৰা হ'ল। This is in 1974.
1974.
Though that land was shown to be have been gifted out of this 8 bigas, 4 kothas, 15 lasses. Earlier it was out of that 3 bigas land was donated to the petitioner.
Now it is by way of said
Khoriddar
persist,
by purchase dakhal hutre, khoriddari dakhal hutre.
persist,
Nothing to do with it.
and the
Then with regard to the previous land. The petitioner has not annexed any other documents here. But from the records, we try to find out how this Mohijuddin name recorded in the Pata number 118 old and 122 new. Now please come to page number. Oh, that's not available here. It's available here on in the record. this document annex
Annex of 5.
four.
Four.
After the death of Mohijuddin.
Yes.
See whose name was entered. That is on, it was corrected on 25th of October 2010. And record reveals, Gatidian. Annex of Puro নাম কেইটা আছে এটো এই অৰ্ডাৰ চিটৰ বাকিখিনি নাই চিটাৰ দিয়া নাই না চিঠাৰ চক্ৰ বিষয়া মহোদয়ৰ 19/11/2009 ইংৰাজী তাৰিখৰ হুকুম মতে উত্তৰাধিকাৰী সূত্ৰে এই পট্টাৰ 114 নম্বৰ দাগৰ 1 নম্বৰ পট্টাদাৰ মহিজুদ্দিনৰ স্থলত জহিরউদ্দিন, বাসুমিয়া, রহমান আলী, সত্তর আলী, বাইনা খাতুন পিতা মৃত মহিজুদ্দিনৰ নামত নামজাৰি কৰা হ'ল আৰু চিঠাৰ একে তাৰিখৰ হুকুম মতে উত্তৰাধিকাৰী সূত্ৰে পাট্টাদাৰ বাসু মিয়াৰ স্থলত হাজেৰা খাতুন, নূৰ ভানু, সাহেৰা খাতুন, ফিরোজা খাতুন, রহম আলী, রহিম আলী, জুনহাস আলী, পিতা মৃত বাসু মিয়ার নামজারি করা। So that serial number 4,
Yes.
no way connected. Patadar number 1, Mohijuddin was one of the Patadar for the dag number 114.
Yes.
Similarly, serial number 4, Baisan Nisa, I
Yes.
think so, was the Sabjan Nisa, wife of Amir Sheikh, was one of the Patadar. And not because of Amir Sheikh was the Patadar of that place, because there is no such remarks in that particular patta. So basically, this 1, then 4, they are the original pattadars.
Mohijuddin Sabjad Nisa, original patta.
Original pattadars. Suna Bhanu. That is why I was trying to find out how come Sabjan Nesa's name will be entered.
Whatever it may be, my lord, one thing your lordship may kindly see. This 1960, even though this 24 document was there, and if it is of some Mohijuddin, the record reveals Mohijuddin, and this is, my lord, they are similar. There is no issue on that. Along with record, this is corroborated. But the question is whether this Mohijuddin and Mohinuddin of Malad is the same person. That has not been revealed from the Malad statement of the Malad DW4, who has come to prove those Jamabandi copies. Jamabandi copies, sir, Malad, there may be correct, those may be exist. Those may exist, but it does not say that these are the documents of these persons, the petitioner and petitioner's fathers. My lord, your lordship may kindly see the statement of DW4. He has said only, my lord, that Jamabandi, so, I have bring with the original volume. The area of Jamabandi exhibit 3 match with original volume. That's true. The Jamabandi is
Yes.
matching with volume. No
Definitely.
issue on that.
But it doesn't prove.
Doesn't prove that it is of these persons, my lord, those persons whose names were there in 1966, 1970. These are the same person. It is not proof. Jamabandi exists. And whether these are the same persons or not, that issue has not come out, my lord.
Lordship, in that, her name had proper, which is Sattar Ali, my lord.
Listen,
Sattar Ali is my uncle, Lordship. He came for the deposition. In his statement, Lordship, his deposition, I have also annexed it. There he has clearly stated, Lordship, if Lordship allows me, I'll read his statement.
yes.
In page number 54, it's written, my name is Sattar Ali. My father's name is late Moizuddin. The second party, Nur Islam, is the son of the elder brother of my father. The father's name of the second party is Amiruddin.
Be very careful.
Lordship.
What is the father's name of Abdul Sattar?
Here he is, Lordship.
Yes,
here,
yes, please.
Moizuddin, Lordship.
Please. That's the reason we are asking you to read.
Lordship, here he has come and deposed.
Yes, just read. How you have proved that just you just see. Sattar Ali came, right?
Yes.
And he has proved, he said.
Yes, Lordship. No, he has his.
According to you, let
Yes.
us see what Sattar Ali has
Yes,
said.
Lordship. Page 54. So that is the time copy. Saying, my name is Sattar Ali, my father's name is late Moizuddin. The second party, Nur Islam, is the son of the elder brother of my father. The father's name of the second party is Amuruddin. And mother's name is Sabkan. Both the father and mother have been voting since 1966. Father of the second party died during 69-70, Lordship. Out of the 5 brothers, 3 have already died and second one is still alive. The second party has casted his vote in 1985. Thereafter, he has been marked as D. I have casted my vote in 1985.
Please come to the voter list. You said that Amiruddin, the father of the petitioner,
Yes, Lordship.
is the elder brother of your father, and your father is
No, Sattar Ali.
Mofisuddin.
Sattar Ali said.
Sattar Ali's father is Mofisuddin.
Yes.
And Sattar Ali said that petitioner's father is the elder brother of his father, that is
Yes.
Mofisuddin.
Mufizuddin.
Right.
Now, Lordship, here I will just like to clarify.
Please come to
Sattar Ali is the stepson of Mufizuddin, Lordship.
please come to the voter list
Yes, sir.
of 1966.
Yes, Lordship.
Kindly show us.
Lordship, here I will like.
Kindly show us from the voter list of 1966.
Yes. No, Lordship, here I would like to clarify one thing. Sattar Ali is the stepson of Mufizuddin, my lord. Mufizuddin had 2 wives. This is not stated anywhere, my lord. Because of which that confusion. Because of which, Lordship, there was an observation that in the Foreigners Tribunal also there was this objection raised. In the very first statement, they had said the proceeding is written statement stated that his grandparents' name, Lordship, in page 67. That's why there has been this discrepancy in the age. It is written, proceeding in his written statement stated that his grandparents' name, parents' name, along with 2 uncle name appeared in the voter list of 1966. In the said voter list, proceeding's grandmother's age was shown 40 years and projecting uncle age, Jahiruddin, Lordship, his name is appearing in all the Jamabandis, shown as 30 years. So it appears that mother and son's age difference is only 10 years, which is biologically impossible. Lordship, this from day one I have been trying to point out, the Honorable Tribunal has not been able to understand, or maybe, Lordship, the council were not able to place the exact facts that Jahiruddin has been born out of the first wedlock, first wife. And then there is Sajan, because that age after which Mohizuddin had 2 wives, my lords. First wife, and then there is a second wife. Sajan Nesa is the second wife, and her name has been appearing everywhere. Sajan Nesa is there. That's why there is an age difference, my lords. That biological age gap which the tribunal could not explain is because Sajan Nesa is the stepmother. Their first mother was Supuljan. And the names of Sattar Ali, Jahiruddin, A. Barik, all they have been mentioned here. All of them, but these are all combined sons and stepsons involved, my lord, of Mufizuddin, also known as Mohiduddin. And Sattar Ali, the step uncle, came for the deposition because their his father, Mufizuddin, and the petitioner is the step nephew. So in that country, that tribunal were not able to appreciate these facts, my lords. Because,
See, Mr. Saliha,
Lordship,
your entire gamut is this, as per the Sattar Ali, that the proceedee is the son of Amiruddin, who
Yes.
is the elder brother of the father of Sattar Ali, right?
yes,
Now please come to page number 20.
yes, sir.
According to you, Sattar Ali is son of
Notice.
Mohizuddin.
Mofizuddin.
Mohizuddin, not Mofizuddin.
Moizuddin.
And father of the petitioner, Amiruddin is son of whom?
Lordship.
No.
Father of the petitioner is the first wife, is Mofizuddin's first wife's son. First wife. Lordship.
My
Amiruddin.
name is Sattar Ali. My father's name is late Mohizuddin.
Yes. Mother's name.
Listen, the second party, Nur Islam,
Yes.
is the son of the elder brother of my father. So your father is Mohizuddin,
Lordship, here this.
and the father of the petitioner is the elder brother of your father.
Lordship,
Now you are saying Mohizuddin is your father. Now from the voter list, kindly tell us. That means, according to you, the father of the petitioner, Amiruddin should have been a son of Gumani, right? Because your father is Mohizuddin or Mofizuddin, you are saying same person.
Yes.
And you are also saying that your father of the petitioner is the elder brother of your father,
Lordship, here,
right? Page 54, you are saying.
page 54, Lordship, here I am.
Second line, the second party, Nur Islam, is the son of elder brother of my father.
My father.
So he should have been son of Gumani, because Mohizuddin is the son of Gumani. But
Yes.
here what is shown? Amiruddin
Lordship,
against
here-
Amiruddin.
If I may, Lordship, here my facts might differ, Lordship, if in the deposition, which is the vernacular of there, Lordship, because from what I have been explained, Lordship,
Mm.
is not this statement, Lordship, if it can be verified from the original statement. I'm not aware, because I was told Sattar Ali's father, Mofizuddin, Amiruddin is step brother, from what I have been told, my lord. I apologize if in the
Step brother of whom?
is the step brother of Amiruddin. Amiruddin and Sattar Ali have the common father, that is Mofizuddin.
But you have said here is your elder brother, but elder brother of your
Lordship,
father.
if the deposition they have stated it, my lords, I'm
Page 55, make it.
55, my lords. If in page 55, my lords, if he has stated that, my lords, then I am not going to go further into this. If he has stated, Lordship, because in my complete honesty, my SME is a little weak. So I am completely relying on the translation. If he has stated in his deposition, Sattar Ali, that his if Amiruddin is the brother of Mofizuddin, then Lordship, I won't go further into it.
First of all, Sattar Ali is the son of Mohizuddin,
Yes, Lordship. And
number one.
as per my instruction, Amiruddin is a step brother.
Fine. He reiterated that father's name is Mohizuddin.
Yes, Lordship.
Right? Voter list of 6670 clearly reflects the father of Amir Islam is Mofizuddin. No way connected to Mohizuddin.
Mofizuddin. Yes,
Land document, Mohizuddin.
Moizuddin.
Right?
Yes.
Now, if father of Sattar Ali, that is Mohizuddin, after his expiry, why land was not given to Nur Islam? Why not the legal heirs of Amiruddin? Why Amiruddin's legal heirs name did not reflect on the date of Mahizuddin?
Amiruddin Lordship had 3 children.
We are not on that.
Yes.
We are asking if Amiruddin is the son of Mohizuddin, then why on the date of Mohizuddin, land of Mohizuddin were not given to Amiruddin?
Because the land which was in possession of the grandfather, it was as per.
Should go to all the legal heirs.
Yes, Lordship.
Why the name of Amiruddin or his or her, his legal heirs are not reflected in the land document? The record reveals everything.
Lordship, I have,
That's why I read.
I'm not disputing that. If Amiruddin Lordship,
You are saying that is the reason you are picking up somebody from somewhere.
yes, Lordship.
First of all, your father is not the grandfather of the petitioner is Mofizuddin, not Mohizuddin. And that is why name of Amiruddin did not reflect as a legal heir, or the legal heir of Amiruddin did not reflect any property of Mohizuddin on his death. Otherwise, the property should have been distributed among the legal heirs. Where is that? Neither in the name of Basiran Nisa, nor in the name of Sabjan Nisa, nor in the name of Nur Islam. Why? Name the sons of Mohizuddin.
Lordship, Lordship, should I, what we have stated, or Lordship, what we have stated in
Yes, yes, please.
in the evidence, Lordship, I think. Lordship, in page 41.
Hmm.
That late Mahizuddin, also known as Mahi Devani, and Shajan Nesa are the grandparents of OP, and Jaharuddin, Amiruddin, Amir, also known as Amir Ali, father of OP, Abdul Barik, Sattar Ali, and Rahman are the sons of late Mahizuddin, also
So
known as,
according to the proceeding,
according to the
Zahuruddin, Amiruddin, father of the proceeding, then Abdul Barik, right?
yes, Rahman,
Sattar Ali
Sattar Ali,
and Rahman.
Rahman. However,
Now in his cross, what he has stated,
Sattar Ali,
the two uncles, one is Sattar Ali, one is Raham Ali.
yes, Lordship.
Also in his cross, as
Yeah.
well as in affidavit said his grandfather name is Mofizuddin.
Yes, but Lordship, he has also stated that Nur Islam is the son of Amiruddin.
Now, after the death of Mohizuddin, the person's names are Jahuruddin.
Jaharuddin, yes, Lordship, is the elder brother of Amiruddin, one of the brothers.
Basu Mia. Where is that? In that particular paragraph 5?
Paragraph 5.
6. You have named him, no?
In the
Yeah.
evidence of, in the written statement?
In the written statement also you have named him.
Yes. There are 7, madam.
There are 7.
Yes,
Page number
page 41, sir.
Where is Basumia? Where is Rahman Ali, not Rahman Ali, Rahman Ali.
That A. Rahman, Lordship, that is,
A. Rahman is your father, you are saying.
no, Lordship. My father is Amiruddin.
Hmm.
My father is Amiruddin. Here it's,
You say Zahiruddin, Amiruddin, Abdul Barik, Sattar Ali and Rahman,
Abdul
Yes.
Rahman, yes.
right?
Lordship,
Only Rahman
here-
you said. Don't bring in
Yes.
Abdul Rahman.
Rahman.
You said Rahman.
Lordship, these are the name, yes.
Now, as per this report, it is Zahiruddin,
Jaruddin. Lordship,
then Basumia, no Amiruddin,
Lordship, I'm not-
Basumia. then
Sure.
Rahman Ali,
Yes.
then Sattar Ali, and one sister.
Yes, Lordship, here, that is what I'm trying to say, Lordship. If Lordship will allow me to put the entire family tree, because in the evidence they have mentioned the entire family tree, Lordship,
Hmm.
which is not in front of me.
Okay, in the evidence, let us see.
Lordship,
Come to the evidence.
no, Lordship, Lordship, here in page number 52, that is in page number 52, tab 31, that I have submitted my family tree along with my all brother and sisters, legal heirs of late Amiruddin in the present processing NRC.
Good. Cross from the NRC.
Lordship,
Show us from the
that NRC copy is not available.
your annexer 1.
I just have the first page, yes, Lordship. Here in NRC, Lordship, if Lordship will see,
That NRC will not help you. It is not final.
yes, exact, that is why, Lordship, I'm not like, here, Lordship, from what I have been instructed with, Lordship, there were the,
You, Mr. Saliha, you just cannot pick from one particular name and then from others. That cannot be a process.
no, Lordship, here, I'm not pressing on these documents that much as I trying to explain the entire family tree, because Mofiz, if we have to look into the picture, like Mofizuddin had what? 8 children, my lord. 5 from one wedlock and 3 from the second wedlock.
Who are they?
Yes, Lordship. That is now,
Kindly give
Lord,
us the 5 names from the first wedlock.
yes, Lordship. And the grandmother's name, the first wife's name has
Kindly give us the 8 children's name.
yes, Lordship. Yeah. Mofizuddin and Sukurjan. Sukurjan was the first wife. They had 5 children, my lords. Jahiruddin, Amiruddin, A. Barak, also known as Batsu Barak, Lordship. Khatun Nesa or Khatun Bidwa,
Where from is? Where is this exhibited?
Lordship. That, that has not been exhibited. Lordship.
Fine, don't bring it.
Uh,
If it has not been exhibited, don't say from without of the document.
Yes,
You have to
Lordship, that
confine
is-
only to the documents that you have
Well,
exhibited
Lordship,
before the tribunal.
That is why I was not, Lordship, that
You
is,
can bring many ABCD,
yes, Lordship.
entire A to Z.
Lordship, that is why I have not pressed on this, because that was not presented in the tribunal, in front of, that is why that is why the entire, there's been a little bit of confusion in the observation. That I have not been, Lordship, I am not pressing.
Say, question is in the land document. You have read out the names whose name was incorporated after the date of Mohizuddin, not Mofizuddin I'm talking about. So some sons, name of some sons of Mohizuddin might resemble the son of Mofizuddin. That doesn't mean that you have proved.
One of the sons have come and testified, my lord, that
That is why Mohizuddin has a son called Sattar Ali. Possible.
and it's that Sattar Ali deposed and
He,
identified.
he deposed that his father's name is Mohizuddin. And you deposed that your grandfather's name is Mofizuddin.
Nur Islam, and that this Amiruddin is the father of Nur Islam. my lord.
Show us from anywhere any land document that Amir Din's father's name was Mohizuddin. Anyway, Mr. Payang, finish it off.
Yes. My lord, so my lord, as I have already pointed out, my lord, only the petitioner was supposed to link himself along with the voter list of 1966 and 70. But he failed to link himself along with these persons, any one of 1966 to 71. Even though he projected his mother's name was there in 1966, that is in different name. The mother name is different in 1966 and 70. So we cannot, my lord, accept, the tribunal cannot accept that, my lord. So that is the point, my lord. So other, my lord, land documents he relied on. Land documents is irrelevant because there is no name of the petitioner. Neither the name of the petitioner is there, nor the parent name, sir. Parents' names are there.
First of all, that settlement officer, the person who came and proved it,
Yes,
he did not prove that.
yes, my lord. They are the same persons. Now, my lord, just I'd like to rely on the document, my lord, one judgment, as I read out last opinion also, 2019 1 GLT 784, my lord.
2019,
1 GLT 784. From para 10 to 16, my lord. That is,
you placed it yesterday, I believe.
yes, my lord. That, my lord, just I'm reading only one para because what is the necessity, what need to be proved, my lord. In order to discuss the complete burden of proof, para 15, my lord, the nature of purport of evidence must be such that lineage is established not only with respect to the person whose name appears in the public document relied upon, but at the same time rules out the possibility of it being linked to any other person having a same or similar name. So one Mohizuddin was there. He is trying to link himself to that Mofizuddin of 1966 and that Amiruddin of 1966. But by to establish that he has to bring evidence so that it will not rule out any to any other person. The link has to be proved absolutely, and it is not linked to any other person. That possibility should be ruled out from the evidence. Here, my lord, here is the case where everything is doubted, everything is doubtful, nothing is proof, my lord. The lineage is not proof. So, if he can prove that, yes, this Mofizuddin was his grandfather and Amiruddin, exactly the Amiruddin of 1966 was his father, and this mother, Basirunnesa of 1966 was his mother, by any evidence, it could have been the best evidence, mother. But there is no evidence at all. Simply, there is no evidence at all. And with regard to the voter list, the oral evidences, it's there are numbers of judgment of this honorable court has said, even the Sattar Ali, my lord, who is trying to, who is coming to the court and saying that he is the brother of the father of the petitioner, my lord, and younger brother, in fact, but his age was 56 years in 2018. There is no pleading, my lord, as though my lord is arguing that the grandfather had, my lord, 2 wives, and this Sattar Ali is the son of the second wife. These are not there in the case, my lord. These are now brought to this, now only, these are argued before the honorable court. These were not pleaded. And if we accept this Sattar Ali as his, my lord, uncle, Sattar Ali's date of birth will be sometime in 1962. If he was, my lord, because he declared his age as 56 years in 2018, his date of birth will be sometime in 1962. And as per statement of the petitioner himself, his date of birth is 1963. So uncle is just 1 year elder than the.
But that uncle is the.
No,
born
that's
of
why,
the-
no, I understood. Even that was not pleaded case. That was not pleaded. So how can the tribunal is not the God, my lord. Tribunal cannot know which is not pleaded before the tribunal. Because it has to be placed before the tribunal. Then only tribunal can give an opinion. Without any material, how can tribunal give an opinion? So tribunal has this, my lord, this document was before the tribunal. The tribunal cannot, on the basis of this evidence of DW2, my lord, DW2, he cannot give the tribunal cannot give opinion that yes, he is the uncle. How can it be accepted? The uncle is just 1 year, my lord, elder than this, my lord, the nephew. So this was not accepted properly, and the my lord, the evidence of DW court, he has said, my lord, though the Jamabandi copies are similar, but he has not proved that these are the same persons. And these documents belong to this petitioner or petitioner's grandfather or petitioner's mother. That is not true. And the Gawabura, my lord, in fact, the Gawabura certificate was rightly rejected. But with regard to oral evidence, it is clear, my lord, from the Honorable Court, numbers of occasions, this judgments, this Honorable Court has said that the oral evidence
Gawabura
is
also
not.
did not mention the name of father, mother
No,
of
no.
the proceeding. If the certificate goes in his oral evidence, he did not
Yes.
mention.
Certificate, in fact,
Let
he
us
can-
assume,
yes,
Mr. Salia said, the
yes.
certificate goes, but history is.
Statement says he doesn't know, my lord, when the father died. He doesn't know when the grandfather died. And my lord, if we see, my lord, on the same way, the Supreme Court has said in case of, my lord, certificate issued by the Panchayat secretaries, that it has to be proved in 2 ways, my lord. First of all, authenticity of the document. Secondly, the authenticity of the contents of the documents of the certificate. If that certificate is not proved by, my lord,
First of all, Gawabura has no right to give certificate.
yes, that are the 2 points, my lord.
Even if the Gawabura is taken into, he
Yes.
doesn't have that power.
But
Your lordship may just, I'm, my lord, pointing out the 2 judgments on oral evidence, my lord, that is 2018 3 GLT 118. 2018 3 GLT 118, that is Bijoy Das, my lord. There it is, the oral evidence is negated.
And the other one,
Other one is, my lord, my lord, WPC 1900 of 2019, Noor Begum. 1900 of 2019. Then another one is, my lord, WPC number 4020 of 2017, Asia Khatun, my lord. All these are, my lord, on the basis of on the
where
proposition
is
of
that
oral evidence.
Gawabura thing was?
Gawabura certificate, your lordship will find it's 1 judgment, my lord, said this is 7451 of 2019, my lord.
7-5,
75
4.
or 7451 2019, my lord. That is there, it is said, the below.
doesn't empower him to give any such certificate.
No, that is, my lord, the Gaon certificate issued by the village Gawabura can never be a proof of citizenship of person. Such certificate can only be used by medical. And in fact, it is, though it is used, my lord, it can be issued only for the married woman. Sometime, my lord, for transfer of his place after marriage. Then, my lord, another judgment on Gawabura.
Where
There-
that, power
yes.
of the
Yes, power, my lord, your lordship will find that is
land
in.
and revenue regulation was
Yes,
discussed.
WPC number 576 of 2019, my lord. 576 of 2019. Mahiruddin, in that case, my lord. Mahiruddin, that was disposed of on, my lord, 0605 2019.
Okay. Your matter with, tomorrow you reply, give it to Mr. Day,
Yes, my lord.
morning. We'll take up that matter first.
Yes.
Pass number to Kalila by Steve.
Item number 9, my lord, habeas corpus matter, 476 days, my lord. Anywhere, my learned friend is also there. Monday, my lord.
My lord, we fix a date on 28th of March,
Why so far?
Oh, yes, my lord, already for Monday.
Monday.
Habeas corpus matter, why do you want now?
18, my lord.
18th.
Yes, my lord.
9 will be on 18th.
Yes.
Monday.
Regarding lordship, item number 5, lordship, record has already been sent, lordship, we received, I think received by the honorable judge. And regarding
It
her
will come.
appearance, lordship.
Will pass the But item number 19 will take up tomorrow
Yes.
morning. Be
First item. All right.
single bench, notice. 19.
Obvious.
19 you are still thinking.
May it please lordship, I'm appearing on behalf of R. Mazumdar in this matter. We have filed our additional affidavit. It has been brought in record.
Please take your.
Yeah. Senior.
part are.
May I
And Mr. Dinath. While disposing of the repetition number, the repetition being WPC number 6 of 2016 prepared by one Sandan Chandra. The court by its order dated 04/10/2019 imposed an exemplary cost of rupees 1,50,000,000 on the corresponding numbers on
Interim page 11, ma'am. 1, 2, and 3. Respond.
the Commissioner Secretary to the Education Department, to the Director of Secondary Education Assam, and 3. The Inspector of Schools, Kamruk District Circle, Amingaon, Guwahati, response numbers 1, 2, and 3 respectively therein for non-compliance of the orders of the court passed earlier on 05/04/2001 in WPC number 1766 of 2000, only 1999, and 02/01 and dated 02/01/2006, passed in WPC number 6779 of 2005. Court preferred by the same petitioner, Sandran Chandrakalita, pertaining to the post of pertaining to a post of lower division assistant in Bamundi High School, Bamundi District, Kamrup, Assam. The state respondents আগত লিখা submitting direct. Though these take respondents pursuant to the order dated 4/10/2019. Passed in WPC number LOI. Prepared the speaking order after hearing the parties. But could not issue the same due to pendency, due to certification of read appeal number, the adjudication of a read appeal preferred by the private respondent Subodh Kolita against the judgment and order dated 4/10/2019 passed in WPC number 286/2016. What is the read appeal number? Any idea?
No, my lord, I was not made, but in the review petition, I think there is,
Mentioned or not?
I think the record is there, my lord, because earlier
I
the,
don't think so. Read appeals record is available.
Yeah. read appeal, I don't think there is any read appeal, my lord. Some numbers 1622 of 2003,
No, no,
75,
after this order passed by the court on 4/10/2019, there is a read appeal.
I have no idea, my lord. Actually, I have filed one read petition challenging that order, rejecting my prayer.
That's a different issue.
Yes, sir. But read appeal, I don't have any idea. I will check, my lord.
Sharma, Maritakam Subodh Kolita. SUBODH. Need to order against it. Read appeal was a file for against this order. Need to order 14/2000. What might you lay you?
मी नाही पता বেলেগে কৈছে যদি গম নাপাওঁ আমি কৰা নাই মোৰ নলেজত নাই মোৰ চেক কৰি পোৱা নাই মোৰ ভিতৰত কোনটো সেই আমাৰ যিটো ৰিভিউ কৰিছে প্ৰাইভেট ৰেছপন্স নাই কৰিছে
I have checked online through name, but it is
We're
not
also
there.
trying, you have the idea.
But no, I was told that there was no appeal pending. It was only because of this review
That is correct.
the entire department was waiting. There was nothing on review.
I have checked name wise, could not found 19 and 20. SU.
I think.
SUBOD सब ना?
H2 ಮಾಡಿದೆ. H2 POD ಇಲ್ಲ.
Unregistered to that asset.
H2 POD ಮೇಲೆ ತಪ್ಪು.
19 never fail.
9 years.
Right. Yeah, right. Will it appeal?
So 20 ever fail.
You may cut it.
Close. Different photos photos. Back to कुटुंब वितर नव्हता SUBUD SUBUD SUBU BA इसके नाम पे 2019 20 21 एनी रिपीट और आए बहुत पॉलिटा
W.
Episode में फाइल का अलग फाइल का कोई भी होता है
Just note down one repetition number.
Hello
5170-2023. His interim prayer was rejected by the single judge. Subodh Kolita filed a writ petition. Notice was issued on 8th of September 2023. Prayer for interim order stands rejected in as much as there is finding against the petitioner that his appointment is based on a select list where there is no signature of the chairman and the other members of the select.
he is the person
23 করেছে 23 করেছে
after the order came na
Then
26 যে আমি এখন অর্ডার দিলো যে we will cancel we will recover everything he must have come after this he must have come against the 26th of June 2002 the order
we don't know. Maybe.
that is the order when we took a decision that will
That's right.
must have
There
been
is another. Repetition His writ appeal is pending, but hasn't been listed.
Maybe
There
that against that rejection of the interim order.
No, the 410. that order. 410 order. 410 2019 order. Writ appeal number unregistered.
Because they must not have filed the prolongation of delay perhaps. Therefore, it never
No,
got
It
registered.
was filed 15922
159
public 2019 unregistered.
unregistered. Therefore, we did not find it in the website.
2019
My
Amaya
filing number was time,
Amaya
number
Amaya.
na पाऊँ.
They did not pursue the matter.
अभी file कौन दिया?
Later. The Secretary Government of Assam in the Department of School Education, after hearing the writ petitioner Sandan Chandra Kolita and the private respondent Subodh DSL Kolita. And pursuant to the directions of this court passed earlier on 4/10/2019 in WPC number 286 of 2016, 05/04/2001, dated 05/04/2001 in WPC number 1766 of 1999, and order dated 02/01/2006, passed in WPC number 6779 of 2005. Found the appointment of Said Subodh Chandra Kolita, as an LDA in Bamundi High School as not judged and not proper, as he was appointed on the basis of a select list where there was no signature of the chairman, members of the selection committee, and also in the instruction of the then education minister. Full stop. During the deliberation of the reviews, the state government authority, state respondents and the Department of School Education filed this review petition for recalling of the order dated 04/10/2019, passed in said WPC number 286 of 2016 within brackets Sandan Chandra Kolita versus State of Assam and 4 others, whereby the exemplary cost of rupees 1,50,000,000 was imposed upon Commissioner Secretary, Director of Federal Registrar of During the deliberation of the review petition, this review petition,
Filing number ये है. आपको को बोलो ये writ appeal का filing number है. What happened to it?
the
Is he here?
by order dated
Telling to place the file.
by order number all capital dash 448841 of
This is the
102
filing number.
dated 19/02/2024. Technically, during the deliberation of this, Mr. R. Mazumdar, standing counsel Department of School Education in bracket secondary, also placed before the court that the state government in the Department of School Education to the Secretary Government of Assam in the Department of School Education, by order number E-48841 of the 10 E-48841 of the 102 date 19/02/2024, terminated this directed this decided terminated the service of said Subodh Kolita, was illegally appointed as to the post of LDA in Bamundi High School in 1999, and thereafter upgraded to the post of assistant teacher in the same school with immediate effect. Full stop. Pursuant to the same, the Inspector of Schools, Kamrup District Circle, Amingaon, by order dated 05/03/2024, terminated the service of said Subodh Kolita and the headmaster of Pamundi High School on 08/08/03/2024. Served the copy inform the Inspector of Schools, Kamrup District Circle, Amingaon, that said termination order dated 08/05/03/2024 issued by the Inspector of Schools noted above has been served upon said Subodh Kolita. After hearing the land council for the particular then test the method. And since the respondents authorities in the Department of School Education has complied with the direction of the প্রত্যেকটা order there. বুঝতে পেরেছেন? Very good. Five 2001, passed in 1766/1999. 02/01 2006, passed in subsection of 6/7/9 2005, and 14. Number. The order of imposition of externally cost of rupees 1,50,000 to be paid by the Commissioner. Director of recall. Pertaining as passed in the order dated 04/10/2019. In the application number 286 public records. Only to that extent, the order dated 04/08 as been specified at paragraph (36) of the order. Only to that extent, the order is reported for the 19 passing application of that they have reviewed and recalled. However, next way, but clear that remain in observation and direction. Passed in the order dated 04/10 for the 19 passing of shall remain. In fact, this order be read together with observation direction. This legal petition is allowed to be extended.
I'm obliged.
From yes, after a long time.
Yes, well, this method has become infructuous.
Absolutely. The present applicant as a petitioner filed an election petition being E.P. number 02 within bracket AP 2014. under the provisions of the Representation of People Act, challenging the election of the respondent / opposite party respondent Mariko Tado as a candidate of Indian National Congress Party from 20 to 0. Tali TLI within bracket ST bracket close Assembly constituency pertaining to legislative state legislative election, legislative assembly election for the state of Arunachal Pradesh 2014 that was held on 09/04/2014. There are two missed cases, right?
Yeah.
Later, the said election petitioner, I represent applicant, prays for withdrawal of said election petition number 2 within bracket AP 2014 and a vote by order dated 13/06/2018 passed in I.A. within bracket C number 109 within bracket AP 2018 filed in said election petition number 2 within bracket AP 2014 order dated directed the election petitioner to issue notice of withdrawal of said election petition in the official gazette of the state of Arunachal Pradesh to the registry of the said court, and thereafter the election petitioner was directed to file an affidavit with a copy of such gazette notification published in the state gazette. Pursuant to the same, the however, the election petitioner, present applicant, did not comply with the said direction of the court dated 13/06/2018. And as such, date ISC 109 within bracket AP 2018 along with the election petition number 2 within bracket AP 2014 was pending for disposal. The in the meanwhile, the period of said term of the assembly for which election was held on February 2014 is already over. Hence this application by the election petitioner for election is overwhelming. Okay. And the said election petition being in process. গতিকে এটা কমন হলে পাই প্রথমে ইলেকশন পিটিশনের মানে the election petition discussed in it. Discussed in it. This is the connected election petition number 02 of AP 2014 has been dismissed to the council. Its interlocutory petition also been a suspect. Okay. Okay, Mr. Davi,
Yes,
KW, huh? Right?
yes, Kedar.
Okay.